What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea!
As you can see, we've had our eye on you for some time now, Mr. Anderson. Mr. Anderson. Oh, Mr. Anderson. 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 Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson.
Hey, everybody. Good morning, good afternoon, good evening. Hi, everybody. How are we doing? What's up? I hope we're all doing fantastic. In case you're wondering what we're doing here, 2 hours early, that just means you don't ever read the descriptions of the videos. It's all right there. It says right there in the description of the video, this is a 2-hour recap before the trial starts. We're going to be looking at what happened yesterday afternoon. I know we usually do an O.J. Simpson thing on Thursdays, but frankly, yesterday was just an insane day across the board. So we're going to take 2 hours here and watch most of the afternoon session to catch everybody up on the absolute mess that occurred in court yesterday. And I wasn't able to watch it live until Hayden woke me up at 6 o'clock in the morning after getting a couple of hours sleep. So I wanted to do that in case any of you missed it. This is wild. This sets up today. Today could either go very, very badly or it could go slightly less badly. So that's what we're going to do today. If you're just popping in here and you want to watch the trial, if you're on the replay crew, whatever, go ahead, skip to the next 2 hours. If you don't want to watch this and you're here now, come back in 2 hours, but just leave it on so we get the few hours. Do that. So, all right, we're going to review the afternoon session, and then we'll go straight into the live session when that's ready to go. And quickly do a little bit of housekeeping here. We have some amazing people and a particularly amazing person waiting backstage, so we have to get through this real quick here. We've currently got 214 of you and 122 likes. Make sure you hit the like and subscribe button. As always, that's how we play the game, and we've got a little live poll set up here because that's what we do. We make a really stupid, lame like and subscribe poll just so it puts in your head that you should hit the like button, because we all have problems remembering to do that. Even as a creator, I almost never remember to hit the like button for the creators I watch, so I just help you out a little bit. And then if you haven't subscribed and you find it particularly entertaining, I'd love to get your subscription before the day is out, as we march towards 36,000 and then onward to 50,000. So today's like and subscribe poll is: I hit the like and subscribe button to avoid a mistrial. I hit the like and subscribe button because I knew you would tell us to. I hit the like and subscribe button so the DA doesn't shout at me. And I hit the like and subscribe button because only Law and Cuck fans don't. There you go. Take the like and subscribe poll and choose the answer which best applies to you. Super chats aren't required. They're not particularly begged for. They're just gratefully accepted, acknowledged, and with the way the chat was burning yesterday, it's very, very hard to keep up with the chat. Slow mode is on right now. If I get a little break, I'll take it off until it gets too fast and furious, and then we'll put it back on as needed. But it's hard to follow the chat while I'm doing this, watching the trial, talking to the guests, spouting my own nonsense. But the surefire way to make sure you get your chats read, acknowledged, responded to by me or any of the panel members is the super chat. Otherwise, it's just a gamble whether it gets pointed out or not. But if you're going to part with any amount of your hard-earned cash, that's the least I can do. That's all that I can do is acknowledge you by reading your super chats. So there we go. That takes care of, I guess, essentially all of the housekeeping details. So let's see. I just got to double check, think this, because I just got out of a board meeting I had to attend. And all right, I guess that's it. If I think of something, I'll just have to go back and play it by ear. So let's first of all bring in our guest that's waiting backstage, a superstar in her own right. It's Natalie Wisco.
Hi. Good
How are you
morning.
doing this morning?
Yeah, I feel bad for Hayden because I am usually way more available in the morning. By afternoon, my brain starts puttering out. So I just happened to be at my office at 6 a.m. today. So you get me early.
Dear God, why are you at your office at 6 a.m.?
I really don't like to work on the weekends if I can avoid it. Or at
It's a
home.
weekend preservation tool.
Yeah, I try and separate that as much as I can. And I would rather come in 2 hours early, 2 days in the week than work 4 hours on a Saturday. So.
And we have
Personal
Mr.
preference.
Gosney in the chat. Hey, Steve, what's up? Good morning to you. All right. So weekend's coming up. This is 2 more days of, well, hopefully 2 more days of this trial. We'll find out about 2 hours from now whether we're going to have any more of this trial.
Yeah, I can't see it finishing in 2 days, honestly, but unless something significant changes.
2 more days this week.
Oh yeah, I thought you meant total. I was like, oh God.
No, they're projected to finish a Tuesday morning or Wednesday morning.
Well, now at least. That was,
Yeah.
I'm sure people have noticed that the third lawyer at the defense table has left. Well, hasn't been there the past few days, and that's because this has gone way over, and somebody's got to keep stuff going in other cases. I'm sure.
That is true. Well, it may all come to a screeching halt 2 hours from now. If we get another mistrial out of this. So that's what we're going to be talking about today. We're going to be catching up on what happened in the afternoon. So much happened, from arguing about people in the gallery, throwing signs to the witnesses, to both parties accusing the defendant of talking to his witness daughter, to the defense accusing the prosecution, the mother of talking to her daughter. Everybody's doing, and she's talking to everybody apparently. And then there was some absolute wild testimony that went on. So that's what we're going to do over the next hour and 50 minutes or so. So before we get to the afternoon session, now guys, spoilers, come on, stop dropping spoilers in the chat here. Come on. Spoilers. Pretend nobody's watched the afternoon session. All right. Let's see. The first thing that happened was that I noticed when she got on the stand, the daughter of the defendant seemed overly, glaringly, obviously coached by probably everybody in her life. The prosecution, her mother, the allegedly deceased guy's family, probably everybody coached this girl. What are your
friends or everybody? That's something that frequently comes up with, if you see people who've been like interviews of people who've been accused of crimes, even wrongfully and not wrongfully, is their families frequently talk about what an ordeal is that they get put through.
Yeah. And then, this poor girl, she's clearly messed up by all of this. Clearly.
Mm-hmm.
And Totally Not a Russian Bot is a new member. Thank you so much, Totally Not a Russian Bot. Appreciate that. Thanks for joining Clean and Sober. Then I think the first time, there were some inconsistencies in the statements and whatnot, but I think the first time it was glaringly obvious that she had been coached. And mind you, she's 14 now, but she was 11 and 12 years old when the majority of the events that are relevant to this case were taking place. So they've got this 12-year-old girl that they wanted to show that she's an honest witness and she's an observant witness by getting her to testify about her father's drug business he's running out of his house, his marijuana growing operations. As I said yesterday, they could have asked her to confirm the color of the carpets, the color of the wallpaper, does the outside door swing inward or outward? But no, they thought the best way, the district attorney thought the best way to check her veracity was to ask about her father's marijuana growing operation.
Well, and I think that shows that they knew that her credibility was going to come up. You don't generally preemptively bolster somebody's credibility unless you're expecting it to be challenged.
Yeah. And I just, it was a slimy way they challenged it.
It was so slimy.
And for Judge Schroeder to say it wasn't prejudicial to do that, I think he was living on a different planet for a minute. But I'm not the judge. The judge says what he says and it becomes law, so let it be written, so let it be done. But this particular example showed that she was coached on how to answer the prosecution's questions for the most part, but wasn't prepared for the most basic of all questions. So this is just a quick little 1-minute clip. The question here is, like I said, they've gone through this this girl who was 12 at the time has testified her father had exactly 72 marijuana plants in the house. They were located between the kitchen and the living room. That he had a watering system. She testified about the drying room where he would dry it out. She testified that he would trim it and cut it as necessary. Or had a little horticulture project. She testified about how it was bottled and kept in the fridge and whatnot. And then this last minute of testimony happened that shows you she was, sorry, didn't mean to do that, Natalie. That's what I meant to do.
That's okay.
This shows she was prepared to answer the district attorney's questions until he asked the one that he thought was so obvious that he probably didn't need to coach her on it.
Mm-hmm.
If what she had said is true, if what she had been testifying was not true, then this could be particularly problematic. Let's see what happened.
It was probably a week before I actually last talked to him. He told me that he had gotten rid of it all, which then when they had went through the house, I found out was not true.
Okay, so when he said he got rid of it all, what did that mean?
Like he had sold everything that he had harvested from it.
Okay, so now I'm just going to show you a couple of quick pictures. So the first picture is which? No, not marijuana.
States Exhibit 1.
Okay, so again, that's States Exhibit 1, number 307. It's going to show up on the TV screen. I'm just going to.
So now, mind you, again, I know I'm just pounding this in because I just want to, I do that. That's what I do. I repeat things way too often. This is a girl who's just testified. Her father had 72 marijuana plants, had a watering system, had a drying room. He routinely cut the plants and trimmed the plants. He bottled it, he packaged it, and he sold it out of the house. And this was the question.
I'm going to ask you if you recognize this item from your father's home.
Do you recognize
this something
item?
Familiar to you from your father's home?
Can I ask what that is?
I don't know.
Oops. Somebody didn't show her the picture of what she had been preparing for, apparently.
No.
Comments, Natalie?
Well, I mean, it works very much, I think, in the defense, for that matter. I mean, without going over these things, it kind of just adds to sort of perception of her teenage, like, grandiose exaggeration type of thing. And I apologize, my meds haven't kicked in yet if I'm not being super articulate. Like a kid, wanting to seem confident about something to sort of connect with an adult in that matter, and then you find out they actually don't know anything about it. Like dating, when people are like, oh yeah, I love cross-country skiing when you've cross-country skied once, type thing.
Yeah. So, but yeah, this is the girl who has testified with this amazing large-scale marijuana production thing that goes on in the house where she lives with her father. But
yeah, and you don't know what dried marijuana like nug looks like.
And specifically had testified that he had this elaborate drying room. to dry it out with, but yet she couldn't identify it.
Mm-hmm.
Oops. And that was on direct examination by the prosecution. So he'd apparently never showed her a picture of marijuana before. Oops. So yeah, that was a bit of a surprise when that happened. And then we had another little surprise coming up just a little bit after that. And this was the daughter being a little bit standoffish. As the day went on, she got more and more snarky, more and more teenage girlish, I guess is the way to describe it. Just when she went full teenager. I shouldn't even say teenage girl, because teenage boys are idiots too. She just went full teenager and got standoffish and got into this rather she's a grower, not a shower. Go to your room. But yeah, so this was her getting annoyed with the prosecution. And just for the record, I'm surprised that nobody said anything and they just let it go, because I know that if I answered a question with, "I'm just finishing your fucking question," the judge would probably have something to say to me.
You're not 14, Jeff, but yeah. That's really the only thing I think she's got going for her. Is she is obviously having a very hard time, and she's a child. Otherwise, SCHROEDER. I mean, you saw with the guy who testified for the state, that was Zachariah Anderson's friend. He had said something like, "Oh yeah, we throw all types of shit in the fire." Like SCHROEDER's look at him and little reprimand. I mean, it's entirely about the age and her ability to cope.
And if lawyers disagree with judges a little enthusiastically, this happens.
Before they
don't get brazen with me.
But let's see what happened to just listen to the end of this. They get in this back and forth battle. She kind of breaks down a little bit, and then she just drops the, "I'm finishing your fucking question."
No. No. I knew.
Well, I'm saying, what did she say?
Her mother was.
I'm not asking.
I already knew everything that my mom knew. She wasn't telling me anything that I didn't know.
Was your mother telling you about the stalking incident?
And do you remember telling her that you actually weren't there?
I do remember telling her that. I did.
And that you just knew what had happened because of a video you watched and from what your dad told you?
Yes. In the beginning of all of this, I did not come out.
I didn't have a question.
Listen to this right here. Yeah, I'm just finishing your fucking question.
No. I was finishing your fucking question.
So yeah, that sort of set the mood for the afternoon, I guess. And we got a couple super chats here before we dive into the afternoon session. Shop Soup says the fact that Natalie deals with his DA office regularly makes her a saint.
I mean, a lot of things do, but
yeah, that's just one of the many.
One of the
Saint
many.
Natalie.
Well, no, and as I tell people all the time, I don't work down here because it's like awesome to live down here. This is or like from a legal perspective. I mean, I like doing these in-depth fighting types of things. This is what impassions, me to keep doing my job. So it's got its pros and its cons.
Fighting for truth, justice, and the American way. Stingy. So you're saying yesterday was the worst day to miss? Probably. If not, it was a very, very close second. And MAGA Mystery Man. Judges letting in extra testimony due to the defense strategy of a bungled police investigation. It blew up now with potential mistrial again. Lol. Even Judge SCHROEDER said at the beginning that he doesn't like the sidebars. He likes the speaking objections so that when it inevitably goes to appeals, that the appellate court will know exactly what he's thinking and why he ruled the way he did without making them guess, which I think it's a good policy if you talk about 3 times faster than he does. But
yes,
that's just me. And Unhung Hero, anyone with a teenage daughter should see right through her attitude. She's clearly not telling the truth, especially her use of words that girls her age, especially these days, don't use. Yeah, there was a little bit of that going on there. What is Natalie's Twitter handle?
It's underneath my name, I think, isn't it?
Let's find out. Yeah, it's right there. NL Wisco. Come on, people. Read the video descriptions and read under Natalie. That's where it is.
And I don't have to remember what it is. I'm just kidding. It's
Yeah.
easy. It's NL Wisco.
Muppets, Puppies, and Kitties Galore.
Oh, yeah, I do. I love. Now I was thinking about Muppets all day yesterday after I wrote that. I just love Muppets.
Alan says, love you, Jeff. Chat Rose. Lots and lots of kisses. All right. Well, then they went into the break, the lunchtime break. And right before they went into break, they were arguing about some hearsay stuff. But apparently during the break, someone sent an email to the judge saying that the defendant was making motions and communicating with his daughter on the witness stand. At the same time, the defense is saying that the mother, who is a sign language interpreter, is using sign language to communicate with her daughter. And everybody was saying the daughter was talking to both of them. And then eventually it got to the point where the defense was the prosecution was accusing the defense of getting text messages back and forth with people in the gallery. This is the shit show that went on in that respect. And we've got it up a little bit faster speed than normal so that we can get through a lot of it. And there's, of course, it's Judge Schroeder's courtroom, where everyone speaks at about 1/3 speed, and there's lots and lots of pauses while people try to figure out what to do next.
Seriously, though, it's really hard to hear in that courtroom. He keeps
Yeah.
talking about. That's why you see those people with those crazy things on, is because that room just absorbs all the sound.
Speaking of absorbing the sound, let's boost this up a little bit. And here we go. This is the afternoon session that you all missed. This is the first little bit where they're arguing about everybody talking to the witness talking to everybody, the lawyers talking with the gallery, everybody throwing signs.
For the ruling. I do have one other matter. So the court provided the parties an email. Mine, it appears the communication to you was at 11:31 a.m. I think.
Well, just so it's clear, it did not come directly to me. The clerk got it. Did you get it as a forward, or was that sent directly?
We did.
Okay. Okay.
So yeah, mine is headed your name. That's the only reason I indicated it was provided by you. But the message, as the court is aware, is that Court TV showed a clip where the defendant used his 2 fingers and placed them over his lips as his daughter was testifying to suggest to not say anything.
Yeah, and what he did was do
Court
this.
TV has played this clip multiple times. They have even slowed it down to be sure that their viewing audience was able to clearly see what happened, the gesture. So we have a copy of what they have played, but there are commentators who are speaking over it, so we cannot tell what the specific question is that it's in relation to, which I feel would be important to the court to know context. Certainly would be important to the state. We have asked Court TV, who have indicated that if the court orders Court TV to provide an original copy that does not have the commentator's voiceover, that they would provide that pursuant to the court ordering that in this courtroom today. And then all the parties.
So this is the first big argument, whether he was talking to it, whether the defendant was talking to his daughter.
What the context is. We know his daughter was testifying. We don't know what the question was or where she was in her answer. I am asking the court to briefly take a look at what we have. I'm asking the court for an order to Court TV so that we may finish our investigation of this. And if we have any additional information we think is relevant, we'll bring it to the court. The court will remember I expressed a concern earlier that I wanted the court to be as diligent as it felt appropriate to try to make sure that this minor child was not in a position where she was being influenced. And so I asked the court to also at this point impose an order that recognizes what has already been detected in the Court TV film.
Well, you're dating yourself because it's not filmed.
Did I say? Yeah. Oh.
Yes. But anyway, is there a response?
Thank you. I have watched the clip. Obviously, what we don't see in the clip is the other side because they're not filming Olivia. I will note that there were times, and that I did observe, that when the state was asking their question, while asking, Mr. Anderson's daughter would look over at him and would mouth something just mouth something. I can't say what it is. I can't say when that happened. I did not personally observe Mr. Anderson make these gestures. I've watched it now on here, but so I can't say if it was in response to that or not, but I will say that that was occurring, and it could be that that was a response to her mouthing while the state was asking a question. So that would be the only thing I have to add to that. I obviously can't speak any further.
Well, that's the second assertion, is that the witness is talking to her father.
But I could have got that earlier. Yeah, we do have a clip, and we would like at least to show the court what has been broadcast by Court TV now multiple times, so at least the court has that available for its in its knowledge.
Well, how difficult is it for Court TV? Okay, and I've been requested to order it, and to me, orders are last resorts. Can I request it?
We tried to go through those options, Judge, prior to coming up with you, and we felt like we heard them clearly.
Okay, well, it is something that may be of benefit to the trial. So, yes, under the circumstances, I will order that you produce that. Is that something that takes a certain amount of time or a foreseeable amount of time? Okay, great. If you would, then. Thank you.
And then, Judge, there was another issue that the defense was made aware of that Attorney Brazel will speak on.
Yeah, Judge. So
now here's the third argument. The first was defendant is talking to his daughter through hand signals to keep her mouth shut, apparently, and she is reportedly whispering things to him or mouthing things to him during the questioning. Now the defense is going to be accusing the mother of something.
Excuse me. This has been brought to our attention too. Obviously, we can't see everything that's going on, but that Miss Beecham is apparently certified in ASL, American Sign Language, and Olivia knows the language. And the observers that reported to us said that she was signing to her. I don't know what about. One thing that was mentioned was calm down. What else was signed to her? I don't know. You know, and I have no idea if Court TV would have picked any of that up. They certainly wouldn't have picked it up on Olivia's end, but I don't know if they picked any up on Sadie's end. So maybe if we're looking at some of this footage, we could look at that too.
I'm sorry, I did not hear.
They only have that clip.
Oh, it's up there.
So I want to report to the court what I know about this, just in terms of reaction. So Sadie Beecham indicates she is not a certified American Sign Language interpreter or a person of that sort. And most importantly, the minor child indicates she does not know that language. So she is not somebody who has that in her ability to understand.
I'll permit you to examine either or both if you want.
Outside into the jury.
Indeed.
Yeah. Ms. Beecham also denies that she did any of that. So.
All right, let's start one thing at a time. Can you run this?
Yes.
And what he did was, there you go, yeah.
Is that a rerun?
Yeah, so because
there's only one incident.
Well, that's the one that they were playing on Court TV that we were made aware of. I don't know if there are others, but that's the one. And then I would play it with sound, but it's pundits talking about what's happening. It's not the.
Have they mentioned nighttime?
They were more focused on what
the Marquette time? No, all right.
They were focused on the efforts of the.
I understand. All right. Well, let's let that sit for the time being. You are. If you wish, you may examine either Ms. Beecham or the child, and that's up to you. Yes, outside the jurors raising.
Am I going to have an opportunity to question the defendant?
Yeah, under oath. Yeah.
Well, the defendant's kind of we can actually see.
Okay.
I'm not in a position, so it may make a difference. I don't know. It's not on the merits of the case, so I wouldn't. Well, I'll tackle that if I need to.
So they plan to put the mother on the stand and ask her about the sign language thing.
Saying to us that they have received this allegation. I have not seen this allegation, so I don't know.
When you say this allegation, you're talking about Ms. Beecham?
I'm right. I'm talking about the one that has been forwarded by the defense table, and I assume they are not. I understand them to not be direct witnesses. They are simply recounting something that has been reported to them.
Who are the informants?
So as members of his family.
Okay.
So
That they observed it themselves here in the courtroom?
Yes.
Okay.
And have evidently reported that Ms. Beecham is a certified interpreter of sign language, which we have told the court is not true, and also have evidently reported that that the minor in this case knows sign language, and she says she does not.
So let me.
So this does not come from the allegation we've described to you is not only on television, but it is apparently someone who has no connection to the case that we're aware of. The allegation the court has just heard has been family members who.
Natalie, what do you think about people from the general public watching this, emailing the court and talking about things that are happening and bringing things to the prosecutor, defense, or judge's attention?
I mean, honestly, it's incredibly distracting and problematic in lots of ways, having been subject to it.
Yeah.
You know, it distracts from so many things going on. That was something that I was doing like live during our trial, is having to field all these things. So much of it is because you can't not follow up on something if it's legit, if you actually get it. So it's more like most of it's all the same thing, you know, repeatedly. I mean, we get like within 5 minutes, I'd get like 50 emails from different people all telling me the same thing while I'm trying to also simultaneously be aware of like 8 million things. So it's very distracting in that way for people who are actually working to have so many people from the public doing that. As far as, you know, content stuff like that, I'm not going to say that if there is something that somebody has personal knowledge of that they shouldn't come forward, though. I think the thing to be aware of is if you aren't the source of the information, something like that you probably, like, it is hearsay, things like that. If you know some type of information that is legitimate and verifiable that you learn from somebody else, I would encourage them to report it themselves, because that reduces a lot of the time and confusion with it when you get things directly from people. So if you do know something or do see something that is coming from your own basis of knowledge, that's one thing entirely. But if it's just you repeating something that you heard from somebody else, they're really, it can be very, you know, damaging and detractful.
Well, thank you. Let's see how.
And that's what I'm saying is I'm not saying that it doesn't make a difference with things.
Yeah.
It's that it can't, and that there wasn't like one thing that helped us, because I don't want to say that. What I'm saying is it's really difficult when, you know, everybody is peppering you with the same thing and nobody has personal information. That's kind of where I was going from with that.
And Chad D is saying, please watch the hand of the woman sitting behind the DA. She does weird stuff. We'll try to keep an eye on that. But let's see how off the rails this goes.
Who have been here all trial.
I haven't pressed Court TV.
Right.
We were what I understood I was being told was that they don't have a video of the conduct which is being described on behalf of
There's
Ms.
no video
Beecham,
of her
but
showing
I
sign
didn't
language.
Ask whether
The
they
camera
have
wasn't
looked.
on her most of the time.
So I don't know if it's if we're dealing with something which is unavailable or something which has not been searched for or found.
I suspect.
What can you tell me?
So they're saying they just don't put the camera there.
So I'm just, the interesting thing, Judge, is, or the complicated thing is that, you know, even if they were to do a search, you would have to have some specialized knowledge what to look for in terms of sign language, because I wouldn't know.
Well, but even the question of whether she had her hands anywhere in a position which could effectively communicate.
And so all of these issues about whether or not she used sign language, they're going to put her on the stand here in just a quick second.
As least as the attorneys reported it to me, and please correct me if I'm wrong, I was told that the allegation, and it wasn't shared with me, it was a family member until now, but that the allegation was that there specifically this person reported that they had seen Sadie, the mother, who is a certified American Sign Language interpreter, interpreting or flashing signs to the minor on the stand, who also knows sign language. This is,
and they're going to testify about that later. So we'll skip ahead here to the testimony.
Rule.
You ordered.
We get to another issue that crops up in a little bit.
That was what when you were talking about having seen other. All right.
Here she is. She's getting on the stand to testify. Sadie's on the stand.
I want to ask you about your employment. Do you work as a care manager / social worker?
No, not anymore.
Oh, you did.
I did.
Community Care Incorporated at UW Milwaukee.
Well, those are two separate entities. One's a school and one is a agency that I work for. Yes.
So, Judge, I'm just going to ask: are family members currently texting defense counsel questions to ask?
No.
Well, there's a court rule that there's no cells to be taken out of pocket. So unless they're pretty efficient at texting, I would assume
I
not.
see
But
that
if they are,
counsel's reviewing his phone. Apologize. All right.
Yep. At UW Milwaukee.
Well, those are two separate entities. One's a school and one is a agency that I work for. Yes.
So, Judge, I'm just going to ask: are family members currently texting defense counsel questions?
Jeff, I think you're muted.
Oh, I just had a good rant. Damn it.
No, sorry. I was gonna say I thought there was like a delay or something, and then I noticed your mouth was moving.
No, I'm just an idiot. All right, let me
Not
get all
an
ramped
idiot.
up
It's an easy
again.
mistake.
Let me, because I was listening to see how much I needed to bring down the court audio, and then I forgot to put it back on. But anyway, as I was saying, that's the important thing right there. That's the next big allegation we have. The first allegation is that he is mouthing, is like using his motions to communicate with the witness. There's an allegation that the daughter witness is mouthing things to her father. There's allegations that Sadie, the mother, is using sign language to communicate with her daughter. There's also some hints that she may be signing back to her mother. And now we've got the allegation from the prosecution that the defense is receiving live text messages from people in the gallery. So everybody's talking to everybody in violation of every possible court rule is essentially what's happening. And speaking of people that are just a violation of everything good and natural in the world, we have Nicholas Starov. Welcome, sir.
Thank you. Thank you.
And
I don't know Nicholas. It's nice to meet you.
You two have not met.
We got a lot of people with N's for their first name. There's Natalie, Nate, Nicholas, Nick Ricada. We just got to get more and more. I like it.
I'm going to change my name to Neff.
Neff? Okay.
Yeah. Nicholas, give us the 15-second who you are.
Okay. Hi, Niklas, but call me Nick, so no confusion there. I'm a junior rep. I do labor law and trying to YouTube for the last 3 months because I thought I watched Jeff here for a few months, and if he can do it, I damn well can.
Yeah, a bunch of blind monkeys can do it. But also, as you can tell from the Scandinavian accent, he's also from Wisconsin and Minnesota area.
Oh, yeah.
Where are you from, Nicholas?
I am Swedish.
My
From
family's
South-
Swedish, so I love it.
Oh, okay.
Bob B says, translate, please.
The land of surströmming, licorice, and smelly cheeses.
Yes. Yeah, they make nice little jellyfish there, like jellied fish. Anyway, all right. Well, we are here with. We got the allegation now. In the middle of the allegation that the mother is using sign language to communicate with her daughter, we have the sub allegation that the defense is receiving live time text messages from people in the courtroom. And that's where we are right now. And this just gets a little bit out of control.
To ask.
No.
Well, there's a court rule that there's no cells to be taken out of pockets. So unless they're pretty efficient at texting, I would
let the interrogation begin.
Counsel's reviewing his phone. Apologize. All right.
Yep. So,
I'm sorry, can I ask one other thing? You courts excluded this witness, so whoever is the individual who made this allegation, I'd ask they be excluded as well.
That makes sense.
okay. So
So that was the person just texting?
Yeah. There are two leaving.
he wasn't texting me, so just relax.
Just relax. He's not texting me.
So from
God,
July
was it
2011
much
to December 2013, did you work at the Deaf and Hard of Hearing Mental Health organization as an employment specialist?
No.
It was called the Threshold Incorporated in West Bend.
I think you're looking at possibly a resume or something, and you are kind of mixing up the places. So.
Okay. Did you attend UW Milwaukee?
I did.
Did you get a bachelor's of education?
Special education, yes.
And in deaf studies and interpreting certification?
I got a minor in deaf studies, and in order to be certified nationally, you need to take what's called a national interpreter certification, and I did not take that.
But you know American Sign Language.
I do.
He actually is looking at LinkedIn.
And you're fluent in it.
Fairly fluent, yes.
Okay. And you taught your daughter as a young child, and as she grew up, how to do it, right?
Up until about Olivia was about 2, she knew animals, her numbers, and her letters.
So the answer is yes. You did teach her.
I did.
And in fact, on your LinkedIn page, you list languages where they have a category for languages, and one of them is ASL, American Sign Language, right?
Correct.
So when Mr. Gravely represented to the court that you said you didn't know it, that was just wrong.
I didn't represent that to the court. I said she wasn't a certified language. I said that the child involved here, the minor.
See, this is just obfuscation. She's not certified, but she's good enough to be certified. So this whole lengthy questioning could have been over in about 30 seconds. Are you certified? No, but I am fluent enough to have been certified, but I didn't take the test. That's the too long didn't read.
Minor does not know the language. I never said that.
There were some representations made which did not amount to what is being questioned now. But I'm not going to break the stride on this. But if necessary, we'll check what was said.
Okay. And so we've established you know it. You've taught your daughter.
I've taught her the basics, very basics.
All right. And you also volunteer at the Center for the Deaf and Hard of Hearing?
No.
So, and is that accurate that you've never volunteered for them?
No, that's not accurate. I used to volunteer for them when I was in school.
Okay. And how long did you volunteer for them?
While I was in school, so a couple of years.
Okay. While you were volunteering for them, did that involve doing translations and interpretations for people?
So in my internship, I did have to do interpreting. Again, I can interpret, but I am not nationally, nor am I certified interpreter. But do I understand the language? Yes.
Okay. And so, obviously, you've heard this discussion. So I'll ask you, while your daughter Olivia was on the stand, you had a sight line to her, right? You could see her clearly?
I was trying actually to not look at her, and I was keeping my eyes focused over at the defense. So, no, I was not directly looking at her. Did I have a sight line? Is that what you asked?
That was my question.
Sure.
Okay.
Yes.
So you could see her, she could see you, right?
I can't speak for her if she could see me, but I could see her.
Okay.
That's how ostriches work. You put your head in the sand.
And so
isn't that like Douglas Adams?
So just a real obvious question.
Guide to the
Were
Galaxy?
you signing her
if you can't see them, they
instructions
can't see you.
What to say or anything else?
No, my hands were below the pews.
Okay. Were you communicating with her in any other way without your hands, either facial expressions or whatever?
There was a moment where she got a little sassy up here, and my initial mom response was to go, shh, shh, shh. So if I did that, that would have been the only thing that I can recall I did.
Okay. And so to your recollection, your hands were below the level of the benches the whole time she was up here?
Correct.
Okay, and then one thing I want to mention, and maybe you guys have takes, you can talk about it, but she was saying, well, she was getting sassy, so I just went, shh, and that may have been it. But nobody's put into context whether that's what the defendant was doing at the same time, going, dude, just zip it, don't be disrespectful. Perhaps that's what he was doing, but no, court TV and everybody else has to make it into a big nefarious thing, like, don't talk about that, keep your mouth shut, don't testify. To me, that was the first thing that I thought of, was he was just like going, chill out, girl, just shut up and listen to the question. But you got to spin everything for the defense in the worst way possible.
Yeah, it's almost like they are putting, she is allowed to do mom things, but he is not allowed to do dad things.
Right. And Natalie, you're muted. You did it too. Ha.
Yeah, I've been typing, so I was trying to minimize that. It's the dad. That would be my thing as well. I'm sure that he's sitting there simultaneously in shock of what she's saying, absolutely heartbroken to see her so damaged, because I imagine she's significantly more damaged than she was before. Yeah. Not wanting her to get in trouble for anything that she says from her mother or from anybody else, and also not wanting her to look like a jabroni. So, I think there's a million reasons why somebody could have done that. And also people just mess with their faces. I know, like, the video of that, he obviously went like this. Yeah. But without actually knowing what she was doing or anybody else doing, she could have been sitting there like with her tongue out, chewing gum, doing something else. He could have been like, keep your mouth shut when you're eating type of thing.
Or you just, don't be a sassy little, teenage girl. Just zip it while the judge is talking. Could have been anything.
Yeah, this is somebody you need to respect. So stop being the way you're being.
4 quick super chats. Don't jump back into this. DA needs his arm wagging stopped and a Xanax. Says Tara Rayner. Hi, from Canada. All. Natalie, is there a soy intake requirement at the Kenosha DA office? Epic ability to adult tantrum by Gravely, Binger, and Sauerkraus.
Oh man, I don't know. I can't say. I will say though,
Rebecca,
no, I'll let you finish your super chat.
No, go ahead.
Oh, I was gonna say something that, like, I will acknowledge. Sometimes people who sign don't necessarily know that they're signing. Like, I had a bunch of friends in college who, like, one of them, had deaf parents, somebody else, studying ASL and stuff. And they would always, like, when they got drunk, also be signing while they were talking. Mm-hmm. And, that being an unconscious thing, I think is entirely different if you're doing it somewhere like down in your lap. But if it's being done like in a way that she can obviously see, I think that's different.
And that's actually a point a bunch of people made in chat yesterday. Mm-hmm. The ones that they have like deaf children and deaf relatives, that they say they do that all the time.
Well, and I also still, because I was a Girl Scout, I know like the alphabet and stuff. So like if I'm trying to communicate with somebody, something like VLC, it's easier to do that than it is to necessarily say it 6 times. Or say V as in Victor, L as in lasagna.
Lasagna. Rebecca Jones says the DA is so high strung, he's obnoxious and hard on my nerves. All of us, we're all there. Phlox, thank you so much for your addition to the chat. As always, Mocha Dick Poon XOXO. I'm just gonna keep adding to my phrases with every crazy ass trial we see. How does this keep happening? These insane cases, because insane people keep doing insane things. That's how it happens. Allegedly. Wolfram, Sadie is just as slimy as the DA. She should have been kicked out at this point. Well, she was warned 4 times 2 days ago to stop nodding her head and shaking her head. Brian Miller, Zach has been covering his mouth with 2 fingers the whole trial. That motion was a little bit whatever, but again, we don't know the context for it. So, all right. let's dive back into this, and we got to skip a bunch. We've got about 1 hour and 10 minutes or so before trial starts, so we're just continuing to go through the last little bit, and we've got 1,000 people here, but only 484 likes. Come on, people, get down there, hit that like button, and take our like and subscribe poll. Oh no, yeah, by the way, subscribe too. So just a friendly reminder to keep this show on the YouTube algorithm by smashing that like button. And just for fun, just for giggles, you get to take the like and subscribe poll. So do me that favor. Let's go.
Okay. Would you say that's true as far as you know for the other members of the family that were sitting around you?
I can say that the other members of the family are in direct line with me. And so if they saw my hands move, they would be the ones to see it.
Okay. Are there other members of the family that are ASL knowledgeable?
Not that I'm aware of.
No, no in-laws, no cousins, no anybody here?
On Zachariah's side?
No, on your side.
Not that I'm aware of.
Okay.
Yeah, I don't believe that at all. If you know sign language, you teach phrases, curses, order beer, stuff like that.
So,
Well, I mean, even with people who aren't as knowledgeable as she is, sign language is still a thing. Like, you do it with babies. I only can imagine that if you actually knew it, how much more you can do.
Yeah. And I mean, say anybody that knows more than one language, I mean, you do things better. You understand. I mean, there's reading, speaking, and listening, and you do one better than the other, and you cannot speak a language but understand it nearly perfectly. It just depends the situation you grew up in, when you was educated, how you were educated, and whatnot. But now the defense lawyer, he's asking her to sign "calm down," and this opens up yet another can of worms.
You would use ASL to sign the words "calm down"?
You probably just go calm down.
So you wouldn't use your hands?
Did you see my hands?
I can barely see you because of the
Exactly, because that's what I did over there. If I did anything, it's below. You can't sign calm down up here. That's impossible. And if I did,
that's just a stupid lie. That's just a stupid lie. I've had deaf friends, and way back in the dark ages in 88 to 90, when I was a missionary here, I actually learned Korean Sign Language to work with deaf Korean church members. And you don't just go, oh, the standard position is to sign down here. Oh, you didn't see it? Well, too bad. You can't see it or hear it. You sign where the person can see it. It doesn't matter where the standard position is. That's just dumb. That's just a dumb thing to say. It's impossible to sign up here. No, it's not. That's the point of seeing it. That just annoys me.
But he would know what I was doing. You don't sign up here. You sign low.
Okay, so you sign low.
Like at your level, you don't sign up here. Those pews are pretty high.
Okay. So you did that then?
You want someone to
I'm
see
saying
it.
they're low. So you're like, if you're like this, you can't see below those pews. So anything that she would be able to see from here to there, I can't see anybody's hands in any of those pews over there. So if I'm using sign language, if I'm using ASL, I have to use my hands.
Okay. When I just asked you to do it though,
I did it, right?
Oh no, that was 35 years ago, Darren.
Correct, because that's the sign.
Korean Sign Language has left my brain
or
building.
Like something like that. Do you do that simultaneously?
Sometimes.
Okay.
Occasionally.
Because that helps them because they can read lips too?
Some people can, yes.
Okay. And so did you do that in this case?
I don't remember. If I did, again, as a mom, if she's getting sassy, I might have said, calm down.
So just for the record, you made kind of a side head mom scolding look, for lack of a better term. But
I think I made that to you. I honestly,
and so, but you could have mouthed those words to her?
As a mom, possibly.
Okay.
All right. Basic questions from the prosecution.
And would your daughter understand any sign language to your knowledge?
Objection.
Well,
speculation.
I don't know. I haven't heard the question.
This is the mom indicating what.
You don't have to
And the testimony is basically taught of the alphabet, animals, and counting. You got the pondering some issues.
So both the attorneys are gone, Judge. Remember, they left when you, yeah.
Get to the good stuff here, wherever it is.
So first would be his brother, Solomon Anderson.
I'm just going to indicate so that we're aware. I'm going to ask to take a look at cell phones of witnesses because
This is the cell phone argument about whether people in the gallery were sending texts to the defense attorney here. Judge
Hi,
gets
sorry.
a little bit of it.
Oh, sorry. I just shouted at someone who just came in. I'm going to mute myself now for real.
Okay.
Anderson.
I'm just going to indicate so that we're aware. I'm going to ask to take a look at cell phones of witnesses because I believe there was texting of counsel before that.
They have a warrant.
But
Absolutely
I'm just
not.
making sure that we're clear. Yeah, so I'm going to ask to take a look at. Yeah.
I'm not going to accept your prohibition when you're not their attorney.
That's fine, but he's making an assertion on the record. I'm allowed to respond to his assertion.
He's asking me if he can examine these people. He wants to look at their phones. I would probably let him as part of his examination of the witness. That would be, but and you're not representing them. And oh, I'm sorry.
Can I
Well,
ask-
here, no.
It appears that there are multiple additional witnesses. I intend to extensively cross-examine these family members, including asking them about materials, because I have, what I thought I saw was counsel receiving texts and reading it. And as I watched individuals leave, I saw them on their phones, and what it appeared to me was texting.
I did get texts from my office
Yeah, no, I'm
who are
not-
watching the live feed.
Sure. So what I'm suggesting, Judge, is that I am in no way going to assume that these people are honest brokers of information. I'm going to, and so because we have a jury waiting and we have a witness waiting.
Yes, and here's what I'm going to do.
Okay.
And you could try to talk me out of it if you want, and as you know, sometimes you can. But my inclination right now is to everybody who has been named will not leave the courtroom with his phone unless I say so. That's number one. Will not make any alterations in the content of the phone's memory. And rather than probe deeper into this, I'm just going to let you examine these people who, on either side of this. You'll be allowed to present that video if you want, and whatever Court TV comes up with, or you could if you wanted to. And then with respect to Ms. Beecham, I'll allow evidence on that subject, all of it to be heard by the jury, because I think it's all perfectly relevant to the case and to their judgments on credibility. Anybody have any reason why that is not an appropriate resolution? So we don't spend any more time outside the jury's presence. Instead, let the jury decide.
Respectfully, Judge, before we agreed that we would do this outside of the presence of the jury, I think it's appropriate to
That may be
continue
what
that.
you agreed, but it isn't what I said.
I believe it was what the court had said, that we would have a hearing on this issue
And we
with
did.
witnesses outside of the presence of the jury.
And we did.
So any further witnesses are going to be in front of the jury?
This jury has been here now. They were told 2 weeks. We're going on, I've lost track. Three. We're going to get to business. I think this is all perfectly relevant. If there's a suggestion that people have been trying to affect the testimony of a child who would be quite vulnerable, then the jury should have that information available, and they can make their own decisions.
Everything and nothing, Steve. Everything and nothing is going on.
Are we past the 2-hour mark yet? So we can actually describe it?
But at what's not shown in that clip, it's out of context in the sense that as soon as he saw that Olivia was mouthing at him, and I didn't see that, but he was alerting us to that. So we can't, we can't become witnesses. We can't call him. So you know, that's as far as that clip goes, that's a problematic area.
Oh, you have no idea how problematic it is. So now,
See, this is the interesting thing. You remember that because the defense lawyer went with the one witness to the wrong address where she went, one of the people that was trying to hook up with the deceased guy, the defense lawyer made himself a witness the prosecution witness made himself a witness in this case. The prosecutor went with the court clerk that the missing guy was trying to date. So that made the prosecutor made himself a witness. Now, by getting involved in this mouthing thing that's going on between the defendant and his daughter, the witness, now the defense lawyer has potentially made himself a witness in this by witnessing what was happening between these two people. So that's why the judge is saying this is incredibly problematic, because now the defense lawyer is a witness to what was going on between him and his daughter in the courthouse.
Clip goes, that's a problematic area.
oh, you have no idea how problematic it is. So now we have lawyers on both sides who are alleged to be disqualified.
Yeah.
So my suggestion at this point, Judge, is to allow the minor child back on the stand. Let's finish her testimony. I'm concerned we might, at this point, that this young woman might be in a situation where she might have to come back. And so my priority right now is not to resolve the issue that we have before us right now. The court has a jury waiting. Let's at least finish this witness. Then the state has one remaining witness. And if the court wants us to talk more about this or litigate this, or the parties can have a discussion about this, sometimes we've been able to work things out previously. We maybe will be able to talk about it again. But at this
Okay, so that's essentially what happened. And there was one point where someone in the gallery, after the judge said nobody's leaving, nobody on the cell phone list is leaving, somebody tried to get up and leave, and the judge yelled at the person and told him he was under no circumstances to leave, but he could leave if he left his phone with the court. And then he made the statement that if anybody is caught texting, they will lose their phone until he's ready to get it back, which could, if it's evidence, be potentially years before they see their cell phone again. And during the break, both sides got together and they said, all right, let's just start over. Whatever happened previously happened previously. We're not going to make a big deal about the sign language. We're not going to make a big deal about mouthing to each other. We're not going to make a big deal about possible texting. Let's just go back to zero and make sure it doesn't happen again. So that crisis was averted. Nicholas, any comments?
Well, one is how this courtroom is, how do I say this? You have the mom and you have the daughter on the stand. Yeah. Why is the mom allowed to have clear sight? She is allowed to be in the courtroom, yes. Yeah. But why clear sight? If they now know, if they knew she knew sign language, she would be, in my opinion, she would have been put in a video conference room where she can watch the testimony. So
that's an interesting thought. Natalie, would any thoughts on that? Is why would it be a viable option to say just put her somewhere where they don't have a direct line of sight?
Yeah, I mean, but that has to be requested or thought of by somebody. It probably just didn't come to anybody's mind. I mean, that makes logical sense to me.
Well, that's a bit of a bad discovery in that case, because if she's what's the English word? If she's good at sign language, that should have been on the defense team's knowledge, wouldn't it?
I mean, I believe so. At least, I mean, so she seems to be. There also is family in the courtroom, and they seem to be the ones who noticed this. So I don't even know if it really was even thought of by a defense counsel until it actually happened live. I mean, it's possible it did, but I don't think that that's something that, is necessarily going to be the first thought you have in your head. Is I have to make sure this person that speaks sign language can't, directly communicate or, can't be seen by somebody. I mean, and now I'm going to think about that in every single situation. So thank you for bringing that up. But I think that's frequently something that if it doesn't happen to you, you don't think about it.
Anything else, Nicholas? Go ahead. Feel free to ask and talk. We've got like an hour, so no, we're not in any big hurry.
Well, you said that now they resolved it. Let's begin over. What's interesting now is what happens next for me. What the DA does when they restart this. If you remember.
Yeah. Go ahead.
Oh, well, the second they restart, he starts demanding that the judge punish Mr. Anderson. Right after they have been outside, came to an agreement, let's start over, we're all good, and then boom, railroading.
And that led to another about hour-long argument with everybody in the courtroom.
Yeah,
and
I said the judge is mad about it's being a 3-week trial, and the DA he said, "Oh, we couldn't have known this." Well, I'm not entirely sure he's being truthful with that, because none of the witnesses so far has, in my opinion, gone overtime. They haven't called extra witnesses, as far as I know. So this week 3 thing, it's solely on the DA, in my opinion.
Any comments, Natalie? I don't know if you were.
No, sorry, I was focusing on something else.
Yeah, I figured.
But yeah, I agree.
Just checking.
It sounds like, well, no, I mean, it could have gone through a lot faster if they'd done things a lot better. I mean, how many delays did we have about things like the Walmart videos, stuff like that? You know, that stuff very easily should have been dealt with beforehand. You know, it's always easier to speed things through when have done things the correct way and are prepared.
I know they said there's not supposed to be any surprises in court, but I mean, inevitably things show up, new things turn up. I mean, how badly does that throw you off your game overall?
I think that depends on how attached you are to your game and how your ability to improvise. That's something that a lot of district attorneys, for example, struggle with cross, because it's not something that they can necessarily plan ahead. They know that there are certain things they have to do, but you have to be able to adapt, and you have to be able to listen to what's said actually in courtroom, because just because somebody said a statement previously doesn't mean they have to testify to it the same on stand. You have to wait and see what they actually say.
I mean, you personally, I guess it depends if it's a surprise in your favor or against you. But do you sort of walk into a trial with the Mike Tyson view that everybody has a game plan until you get punched in the face, or are you pretty set and you just deal with things as they come in, or you just? I guess I'm asking, like, how is it scripted, or do you tend to be more go with the flow and take things as they come?
It depends upon what it is, and a lot of times the type of witness. If it's somebody who has a diminished mental capacity, or is incredibly anxious, things like that, you have to have a little bit more of a structured direct, and it's a lot easier to structure direct than it is to structure cross, because cross is a response, so you don't know what the other person is going to say until they actually say it. It is not necessarily difficult to structure direct, but it really depends upon the witness that you have there, and I think also it has to deal with proper prep. There's a difference between coaching somebody and preparing somebody. Like when I prepare a witness about direct, I make sure that they know, like, my questions aren't supposed to trick you. Like, I can't be the one to say these words. So if there's a question that I ask you that sounds like a really dumb question, it's probably only dumb because I know the answer. You have to pretend that I don't know the answer and that you're telling me, because I'm trying to have you say things instead of me saying things. And I think that is something that, frequently gets neglected in prep is, that. And then also, I always, when I prep a witness, I tell them, listen to questions on cross and always remember that I get to ask you other questions again. So if you have to say yes to something you don't want to say yes to, or if it's something that has a longer explanation, just know that I'm making notes and I'm going to come back and hit those things. I think you also have to remind the witness on cross, especially people like this, that, I'm going to object and I'm going to come in there and, stop them if I think they're giving you a hard time, because that's not fair to you. I think it's just, you have to prep people the right way.
Well, thank you for that insight into what happens in real courtrooms.
Yeah. I mean, at least that's, maybe I just over prepare, but.
Well, I don't know if you can be over prepared.
Well, and that's what I think too. Yeah. Is because something's going to go wrong in every single trial. It always does. And you try and control the things that you can and be as prepared as you can, but you have to be able to adapt.
Oh, and speaking of things going wrong, hey, wow, that's a perfect setup to segue into our next major battle. But first, 4 quick super chats to get out of the way. Tara Rayner, you can hear the snark in her voice. Her daughter gets it nowhere strange. Gets it nowhere strange. I say, okay, yeah. Gets it from mom. Sadie, Becky, and Junior's buddy need more scrutiny. That text is more sus than Zach. Hopefully we can get to the text on during the defense's part. Flux, you typically sign at the level of your chest. She can absolutely sign without people noticing or without even know she is, but she knows she is. Bald Eagle 1787, trials like this with problematic DAs and spineless judges show how useless the system is. It's not useless. It's just sometimes doesn't work the way we think it should. Don't even get me started on appeals. Less than 1% overturn rate. And Squizgar 2322, how long the jury has been there is irrelevant to whether the testimony should be in front of the jury. Well, that's absolutely true. I think he's just saying, look, they've been here long enough. We're starting to get into problems with employment, problems with working and paying bills and whatnot. So let's keep it moving as quickly as possible, I think, is the gist of what he's saying. But now we're going to jump forward here about an hour with the girls back on the stand. The judge is just telling the jury that sometimes evidence and testimony comes in that you aren't expecting. And dear God in heaven, we weren't expecting what happened 10 minutes after this starts. Oh, and by the way, again, just a quick little shout out to all of you, the 1,261 of you that are here. The live trial will start in approximately 45 minutes. Before then, we're just catching up on yesterday afternoon's shenanigans. So enjoy that, sit back and enjoy that, participate in the chat, and do me the absolute honor of giving me your like. Hit that like button and hit the subscribe button if you're so inclined. But I would appreciate the like so we can get it out into the YouTube algorithm. Let them know that people that are watching this right now live like it so that they recommend it to other people and draw people in. Thank you so much for that. Deeply appreciated. Let's watch things melt down over the next 10 minutes.
Sometimes character evidence does come in during a case. And it happened earlier on. I'm not sure if it was while you were here or not, but I made a special instruction to the jury that the evidence is not received for the purpose of showing that the defendant has a character trait or character, and for that reason is likely to have committed the crime charged. This evidence, for example, this reference to a firearm in California. And by the way, some of those laws have been ruled unconstitutional.
And this is what sets it up. There was a story that the dad had a firearm, and both parties agreed they're not going to talk about this firearm other than just the briefest mention that it exists. That's what he's telling people right now. But unfortunately, not everybody plays by the rules.
But that's not really directly on point here. But it doesn't bear on whether he's committed the crime charged in this case. So I will instruct them now that they're not to consider it in deciding that he's a bad character, and for that reason is more likely guilty of the crime charged against him. Any question about that? So that's my job in taking care of the character issue. You can just answer the question.
Okay.
Should I repeat the question or do you remember it?
You can repeat the question.
Okay. So my question was, why did you decide not to tell your mom right away that you had been present on April 24th and peeked in the window?
So growing up, I definitely groomed. So
I guess I'm going to ask that be struck.
She said she was groomed?
Sure, it's.
I mean, what the fuck? Really, what? What the heck? I was definitely groomed, and she just like rolls over that like nothing. That's weird, I think. Maybe I'm weird, but I think that's some pretty weird testimony.
Yeah, just the word groom. She is saying it in relations to the alleged crimes her dad did.
Yes.
I'm not, if I heard just that word,
yes,
I'm associating it with something completely different. And so
Right.
did 90% of law and crime chat.
Yep, and I think that's part of the reason why we wanted that struck. Yeah.
She said she was groomed?
Sure, it's.
Yeah.
It's almost a legal conclusion. Okay, I will do so, Judge. Thank you.
You can go ahead and answer.
I was basically controlled to do the things he was asking of me or instructed me to do. So I didn't have that freedom, if that's what you're asking. I still thought I wasn't allowed to talk to detectives or cops or any of that sort. So
Well, you shouldn't do that anyway.
Okay, so now I'm asking
Unless,
about,
of course, something bad is happening
so,
to you.
So this is a different question now, okay? So the topic now is that you were asked on cross-examination, did you discuss with your mom a bit the what had happened when in terms of your dad looking in the windows and people looking in the windows when she and Rosalía were at the house on April 24th, okay? So you said, I did discuss it with my mom a little bit, and then you said, I told her I wasn't there. So at first you told her you weren't there. You didn't look in the window yourself, okay? And so my question was, why, this is about your mom, why did you choose not to tell your mom that you were there and peeked in the window at first?
So basically, why did you lie to your mom? Or were you lying on the stand? Now we can raise her credibility because she's either lied to her mother or she just lied in court. One of the two.
because I was still under my dad's mentality.
I have no further questions.
All right. Now,
Yeah, thank you.
put it down to normal speed here for a minute.
The state asked you on
For 5
redirect about different times you talked to law enforcement again. There were times in this case, though, where you not only talked to law enforcement, but the district attorney, correct?
Yeah.
And you've had meetings at the office to go over your testimony several times.
Not like that. I think it's the same way that the DA meets with their clients. I think there's not, we didn't discuss, I think we're discussing something.
No, I asked you, I'm sorry. The question was whether you met with the district attorney, you, not other people.
Yes.
Whether you met with the district attorney several times to discuss your testimony.
Not about my testimony, about the general.
Several times.
I cannot give you a number.
When you were at those meetings, you didn't talk about your testimony at all.
What do you mean by that?
You didn't talk about what you were going to say or what questions were going to be asked. None of that was touched.
I mean, to me, I think those are pretty fair questions to ask if you're a teenager.
Mm-hmm.
So they were asked then.
I mean, yeah, if you're a teenager and you're being put on the stand, what are you going to ask?
What the attorney is asking.
Yes. My answer is
You
yes.
don't have to justify what happened. In fact, I'm going to tell the jury actually that it is quite common. In fact, it's expected that attorneys will meet with witnesses as much as possible before the trial for a large variety of reasons. Oftentimes, it reduces the number of breaks that the jury has to take. So that the lawyers are acquainted with what can be expected. It, over the years, sometimes develops a bad name of coaching, which is suggestive that witnesses are told to say things that are not accurate. That is not permitted. But it is normal for the district attorney to meet with the witness or witnesses and the defense attorney as well. Okay, any question about that? Okay, go ahead.
In meeting with, basically what I want to get is, you met with a lot of people many times.
Correct.
You talked on redirect about the unregistered gun in California, but you never saw that firearm, correct?
Now, what happens over the next 4 minutes is some of the, I don't know if bizarre is the right word, but some of the strangest things I don't even know if it's strange. Wild. I guess wild is a good word. Some of the wildest things. It's one of those you can't handle the truth moments. The Perry Mason moments, if you will. This is and unfortunately, there's a lot of harsh treatment and harsh comments about the daughter in chat, brat, and calling her other little names. But this is a girl who is legitimately traumatized by this situation, being pulled between two parents. One of her parents is possibly going to prison for the rest of his life. She's in a bad situation here. She's got to testify against things. And even if she was eager to do it for whatever reason, reality does set in. But and this is where I hesitate to be overly critical, because we're about to watch, or listen to anyway, a 14-year-old girl have a breakdown. So I mean that is the downside. I mean, sure, I have my thoughts about the veracity, the honesty of her testimony, and a lot of problems I've got with her. But we are gonna listen to a 14-year-old girl have a breakdown. For what that's worth. This next 4 minutes is wild.
In what circumstance?
Because she was, and it all started with this question: that firearm you were talking about in California, you've never actually seen that, have you?
Correct.
In what circumstance?
The unregistered gun was in California, right?
At one point, yes.
So you're saying then the gun wasn't always in California?
No.
What kind of gun was it?
Do you know?
I'm not aware of guns like that. I don't handle guns like that.
You said guns like that. What do you mean?
Meaning, I don't know. Meaning, I'm not familiar with guns like that, but I can tell you there was one.
What color was it?
Black.
Was it long, short? Can you describe with your hands?
It was short. It was probably a pistol of some sort. I'm not sure.
Okay, where did you see it?
It was at the Mech 1 house.
So you say that this unregistered gun is in California to law enforcement. Up until today, did you ever say anything about this gun being in Wisconsin?
when I had talked about this gun, there were other traumatic events going on in my life. So this isn't.
You don't have to defend your answer.
I'm trying not to defend it. It's what happened. It's legitimately what happened. Like, there were other things going on, and this isn't something that's related even to this situation.
But if you
It's
listen,
not.
and I'm not, don't take this as a scolding. I'm saying, listen carefully to the question and just try to answer just the question. And if there's more to be gone into, the lawyers will usually cover it.
I was threatened with that gun.
There's the bombshell right there that yeah, they were all agreed we were not going to talk about anything other than the existence of the firearm. Then she drops, unprompted, unasked for, blurts out, I was threatened with that gun. It's at Dad's house, so of course the implication is my dad, the defendant, threatened me with that gun. That is a bombshell, especially as it was agreed that nothing would be discussed about the firearm.
Yeah, but a few seconds earlier, she said it had nothing to do with this situation.
Yes.
And then the bombshell. So speculatively, yeah, might be in her dad or his associates. It could even be in her mom. We don't know. And hopefully we'll never find out.
But we know what the implication is. Everyone's going to be going, oh my God, her father pointed a gun at her. Yeah. Chandler, welcome. Just in time for the bombshell again. And now I had gone to sleep last night, and I had been asleep for 2 hours. And this right here is exactly when Aussie Overlaw'd Hayden called me and woke me up and said, just get on to stream. And we watched like the next hour. This is some interesting courtroom drama here. And looking at Judge Schroeder's initial reaction, he's extremely unhappy about this.
For your information,
Judge, I'm going to ask that be struck. That wasn't.
That's a bewildered judge right there. That's an oh shit look from the judge.
That wasn't my.
No.
Repeat your question.
It will come as no surprise to you that you're going to go into the library for a moment.
He's talking to the jury. And then the jury goes off, and there's a look here that the judge has. We'll bring it back up to 1.25 speed. I want to wait for the camera to pan down.
I think I need to know more before I go any further with this. Would you talk to the microphone?
It had nothing to do with this situation. It had something to do with I don't know how to answer this question.
Okay.
It's a hard question.
See if there's any other.
And this right here is a perfect thing. The judge was absolutely perfect here. He did a great and wonderful thing, which should have been done. At this point, he said, okay, this girl's giving testimony. We don't know if it's going to be pro-mom, pro-dad, anti-mom, anti-dad. He told the clerk to go out in the hall and see if there are any lawyers wandering around so that he can appoint an independent lawyer to act on behalf of the daughter. So that's why he's saying, are there any lawyers walking around out there? So he finds a lawyer to act independently on the spot for the girl to protect her interests as a minor witness, which was a very, very good thing the judge did. And let's see how that plays out.
Okay.
It's a hard question.
See if there's any lawyers in the hallway. Well, I want to get let's see what's going on. Are you familiar with what's being discussed?
Yes, in the most general terms, and certainly we don't expect to go into it.
He's so happy.
I was just
Given how she's feeling right now, I will just leave it. I won't ask any further questions about the firearm.
Will that be the end of the discussion on this, or is there going to be more?
No, I don't.
I don't mean questioning. I mean, is there going to be more? Is it going to play a role in the case at any point?
Well, I don't intend to. I never intended to bring up anything in any of these areas, and I don't intend
Oh,
to now.
I didn't either. That's why I asked her not to go into any specific
Barth.
detail.
Mr. Barth, would you come up, please? Isn't that Mike Barth back there?
Yeah, it is.
Come on up, would you? Would you come up, please? Would you do me the favor of taking on this lady as a client?
I certainly would.
All right. I'm going to appoint this man to represent you. Not that you need a lawyer, but to give you advice about how the law works if you have questions. Okay?
That was very
Thanks,
good of
Michael
the
Barth.
judge.
That was kind
And
of him.
is the jury in the library?
The break room across the hall.
Yeah.
Take her to the soda room.
Thank you. Yeah.
Wait, I just don't understand why. I mean,
Oh, I have a comment. Sorry,
Yes.
since I'm looking in the background about the court TV
Thank
or
you.
whatever the
Okay.
camera's cutting out.
Yeah.
That was actually something with Rittenhouse. So court TV had left something mic'd when they shouldn't have. And Schroeder was very, very, very upset about it. So I imagine that them cutting to the seal and killing the audio is just them being very cautious, because I'm sure that Judge Schroeder told them if they did anything like that again, that they'd never be allowed back. So I think that's just because of that, trying to check and see whether or not, because it is hard from the back where they're sitting because of the sound. You can't necessarily tell if something's, said kind of in private to the clerk, or if it is something that is part of like an argument. So that is the reason, I believe, for them cutting to things frequently, is because Schroeder had issues last time.
Makes sense. And I guess while we're stopped here, great to Matthew Self. Nice to see you invested in Runkle of the Bailey Cask 20 year. It has aged quite well. Sup, Nicholas? Good to see you. And another Nick Naylor says, "Who's the dirty hippie?"
Dirty?
Not you. Not you. You weren't here, Chandler. Flux says, "No, I think she got caught in a lie and did what she could to bail out. With everything I've heard, she got caught in a lie and just kept going." And go ahead.
The DA said he knew of it in broad terms.
Yeah.
So he definitely knew about what happened.
Yeah.
But so maybe he was baiting the defense and did so successfully.
And Mega Mystery Man says the DA set this gun trap. He knew the content. Xcomer Triple Z, DA objected to get into the gun thing, knowing about the treat and defense had not been told about that. Is that not an issue? This whole thing is an issue. I mean, I don't want to be flippant. This whole thing is an issue.
Well, and something,
yeah.
Sorry to interrupt your super chats, that somebody had commented on in the chat is that this girl should have had an attorney like 2 years ago.
Yeah.
Yes.
That is something that I think is egregious and slimy of the state for not requesting. Because regardless of whether or not a witness can afford an attorney, they can be appointed one. Especially if you're dealing with a juvenile witness and somebody whose credibility might be at issue, you should be wanting them to have an attorney.
Yeah, and I mean, good on the judge for doing it now, and good on the guy that stepped up and said, "I don't know anything that's going on here, but yeah, I'll step in."
Yeah, I
Good
like
on
the
him.
way that Schroeder explained it to her, like not that you're in trouble, not that you need a lawyer, sort of, but like so that you understand the law better. And I completely agree with what Natalie is saying. She absolutely should have had counsel. I don't understand why she didn't. That doesn't make sense to me.
Well, and that's something that, like, for example, in divorce cases, as there's frequently adversary counsel that is appointed to represent the child after they reach a certain age to make sure that the child's actual wishes are reflected, because you can't trust parents in this going back and forth context to actually respect and not manipulate the child's wishes.
Would that be a guardian ad litem, or am I thinking of the wrong thing?
No. Well, it depends upon where you're at. In the state of Wisconsin, a guardian ad litem's job is to represent the best interests of the child. That is different from what the child wants. So a guardian ad litem is a detached person who represents a concept. Adversary counsel represents the actual person.
I see. I'm not sure if that would apply or be relevant here, but I was just curious. Thank you for explaining that a little better.
Problem.
All right, two more super chats, and then we're done. Then we'll get right back into the last about 20 minutes. But of course, they always start about 10 minutes later. We'll just go as long as we can and then switch over to live when it goes live. Amanda, the jury will never know. Judge argued the dad was never implicated. DA said, well, yes, he is the alleged person who threatened her. And Boomer Wow says, still odd to me that she guesses it's a pistol. Yeah, I mean, yeah. Whatever. All right. Yeah, you know, it's gonna happen. I don't want to say she's a liar. She's just not telling the truth. I don't know. You know what I mean?
I think with this witness, it's very difficult. You're in very sensitive territory because on the one hand, it's very clear that there are elements of coaching. It's very clear that there are elements of her testimony that seem rehearsed. And it's obvious that she has been in the middle of this custody battle, which is very fraught with a lot of emotion. She's in the middle of, you know, her father's murder trial, which I'm sure has taken an enormous emotional toll. Yet she's also, you know, acting out and behaving in such a way that is not becoming to, you know, to her as a person. And it does not look favorable to her. You can take one or the other stance, you know, you can have empathy, and you can also recognize that, you know, she is old enough to know the difference between, you know, a lie and the truth. And it's you know, I wonder, you know, what elements of her testimony are truthful and which elements are not truthful, and where that's coming from and what her motivations are. She's clearly a smart kid. It's just really sad to see her in this position, and it's really sad that she didn't. I really think that if she had an attorney, I think a lot of these problems might have been prevented, unfortunately. And we won't know how much better this could have been, but it's a problem.
And Jason, yeah, go ahead.
It also goes back to how was the girl interviewed, because during the trial, we've heard that multiple cops, the DA, has interviewed her. And at least here in Sweden, you have one designated interviewer who is specialized in interviewing children.
Yes.
After that happened after we had a similar to Satanic Panic in Sweden. Yeah, and after that, with implanted memories and stuff like that, after that, there's a, I believe it's a special training, almost, it's over the course of 1 year, it's 3 educational events of 3 days each in how to interview a child. I don't know if you have that in the States.
We do have specialists. I mean, that was mentioned in the chat yesterday. I believe people were saying, you know, that she should have been interviewed by a trained specialist, somebody who knows child psychology, somebody who specifically works with children in, you know, in a police setting.
All right. We got one other question here, then we'll jump right back into this and watch as much of this as we can. Jason J says, so should my son have a lawyer since he witnessed me being assaulted here in Two Rivers, Wisconsin, and will be called to testify? Well, this is not legal advice at all whatsoever. This is just my personal opinion. Talk to a lawyer, consult with a lawyer, and see whether that lawyer in your jurisdiction believes he would be better served with or without a lawyer. I'm certainly in no position to comment one way or the other. I would say consult with a local lawyer to see whether you think it would be in his best interest to have one. That's really all I can say here. Not giving any legal advice and whatnot. I just give legal advice, not legal advice. Kime says, during the ASL-ish, chat was suggesting Natalie contact the defense. Ari, the DA mouthing die, die, die during witness testimony. Do you know them? Natalie knows everybody that's involved in this. She's there. So let's jump back into this and watch how this plays out. Come back, audio.
I'm honestly not, because this is new information about this firearm being here. This is the first time I've heard about this.
State, are you familiar with what she's referring to?
She has in, well, what?
Yeah, so in the most general terms, when we had met with her one time, she had discussed the firearm piece and then had relayed to us briefly a traumatic event surrounding the defendant, that firearm, and herself. And so that's...
And it's not an incident near in time.
Correct.
It's not what?
It's not near in time.
It's not near in time to this time frame we're talking about. It was, removed from that, so.
Yeah, I have no idea about whatever the state's reporting. It was never told to me.
Well, apparently the state doesn't think it's relevant, so I don't know if they would need to, but
That's fine. I'm just giving the court context because obviously I was just going into it because the state brought it up and I just wanted more answers. I didn't know asking this line of questioning, it would lead to this because I didn't know of this situation that they're claiming.
well, the question is now how to handle that with respect to the jury, and I guess if it's irrelevant to this case, then the jury could be so informed. She hasn't accused anyone in the presence of the jury.
Well,
the implication is enough.
Yeah, the implication is definitely
That's maybe
there.
a curative instruction or something simple.
Is everybody okay with that?
A curative instruction that would say...
Just tell the, I would just tell the jury.
The testimony about the gun is irrelevant and you should disregard it. And
Well, it's not irrelevant in the one aspect, which is it was something she was concerned enough about that she asked for her mom's permission to talk about it. But what she just described in terms of circumstances with the gun is something that the state believes is irrelevant.
That the state believes
is irrelevant.
Okay.
Then I'm going to ask,
go ahead.
Sorry, Judge.
That's right.
I guess let me hear what you're going to propose first. Because I don't want to say something if it's
strategy.
Yeah.
My inclination is to tell the jury that we've gone to further depth in this subject, and that the statement that there was a threat made involving the firearm is not relevant to this case. There are no further details about it that would be relevant to this case, so that they should disregard it entirely.
I agree.
But those who agree are going to be bound forever to this agreement. So it's not going to be an issue that's going to pop up at some later time. Talk it over.
Mm-hmm. All right, let's fast forward to some testimony here.
More. Right there. Out. You're leaving.
I wonder who that was. Do we know who that was?
Right now. You. Second row of, no, come forward. More. Right there. Out. You're leaving. The spectator was reacting to the remarks which were being made, and I think it made pretty clear I wasn't going to tolerate them. Okay.
I don't know who that was. I wish I knew who that was and what happened. Oh, okay. Anyway.
Terribly disruptive.
Okay.
The jury wasn't here, so if he
The answer is in chat if anybody wants to know. All right. We don't need to watch this. We can fast forward through this.
Relevant.
No, that was not what I proposed. That what the witness's last remark regarding a threat is agreed as irrelevant in this case, and the jurors should disregard it. That statement. The line of questioning was not contaminated. It was strictly what the witness said, and I'm not saying even that was contaminated. It's that particular comment, I'm told, is irrelevant to this case.
Yeah, my only question is, does it suggest that the witness has made some mistake by answering that way? Because I think the answer was a logical answer to the question. So I don't know if it suggests that to the jury.
And Judge, what I'd like to chime in here now is that obviously the defense objected to going into this unregistered gun in the beginning. Just got in, the state asked it. I asked some follow-up questions on it. The state knew all these things about what she had told them about this particular incident.
Actually, the question right now is whether you want to agree to.
I do want to agree. I was just trying to make a record, Judge, from the defense's perspective of the state. It's fine. It won't need it.
I applaud you for making your record
Thank
as an
you.
attorney, but I also put in this stipulation that this closes the matter out, and it's not going to be the subject of any attention from the court hereafter. If everyone agrees it's irrelevant, that it's to be disregarded, and it is, that's in no way suggesting the child has not testified truthfully, only that any threatening behavior does not involve the defendant.
That's not true.
Yeah,
The
That's not true?
The threatening behavior is alleged to be from the defendant.
Not according to the testimony.
That's not what I.
It's not that was not the testimony. So
What was the testimony?
the testimony was that she was threatened. She didn't say who. She didn't say anything. There's no factual basis for that whatsoever.
That she was threatened with that firearm.
With this
She
firearm.
said she was threatened with that firearm, and then I excused the jury.
Right. Okay.
And I did not, after that, hear any reference to the defendant having been associated with a threat.
Okay.
The
And
implication
I
is
interpreted
there.
What you said to me to confirm that. And then I thought, well, he's the DA. No, but of course, you weren't the DA of wherever the threat allegedly took place, which is, quote, Wisconsin. But
Okay. Well, so the current state of the record is she says, I've been threatened with this firearm, but it doesn't say who threatened her.
correct. So I intend
Is that
to.
your recollection? I took it as that she had said he threatened, but I may be wrong.
You are wrong.
You're definitely wrong.
Okay, here's counsel.
I'm wrong?
No,
We are wrong. Okay.
you're never.
I'm not used to being.
No,
You're never wrong.
I would never ever suggest that. But I think the way you phrased it was accurate to sort of summarize it for the jury and then say disregard it and it's irrelevant to this case.
Okay, I'm gonna try it again now, and this is if you agree to it. If you don't agree to it, by the way, the alternative is that we'll have to address it. I can't just leave it out there. So what I propose to do is to tell the jurors that the last response that was made by the witness, we've examined it and the circumstances, that it is irrelevant to this case, and there was no accusation as to whose conduct she was describing when she referred to having been threatened.
Mm-hmm.
So does the court feel we thoroughly examined this at all? So I don't, if the court, is the court saying that because you think it provides them some ballast for then what we do? Because I as far as I know, we have not examined the details of what she is saying happened in that regard, right?
Well, first of all,
I mean, I've just.
First of all, if we do examine it and it turns out it does involve the defendant,
right?
Tell me how to avoid mistrial.
Yeah, no, I understand. I'm just trying. I'm just trying to get wording that is fair. I got where the court is.
I think an even cleaner way to avoid a mistrial is to just strike that entire question and answer period.
About
just yes, the reference to the gun. and just strike it completely.
So we don't agree to that, but we are willing to strike the last question or two.
No.
But the unregistered firearm was brought up, and the court has already given a cautionary instruction to the jury verbally about that. So they brought up, they opened the door. The state is not willing to leave a discussion under cross, as we described before, where the accusation is that there's improper discussion when there is an honest answer. But if we wanted to simply go back a couple of questions in the inquiry from the defense and strike those and indicate the jury is to ignore those questions and answers, I'm agreeable to that.
This is why there acts evidence coming in when the state talked about how they want to ask about this gun. And the problem with them knowing this information because of a conversation they had, and the defense then left in a situation where the jury hears about an unregistered gun. Maybe I should find out a little bit more about that. And then it leads into this. I think because the witness has testified that Mr. Anderson had an unregistered gun in California and has now said that when this gun was here, allegedly, she was threatened with it, that the inference that's going to be left with the jury is irreparable if we do not strike everything about that unregistered firearm.
Well, I don't agree with that about the irreparable part. I don't agree with Mr. Rivley's suggestion because I did think that, well, I'll leave that at that. I am going to tell the jury that the last remark, which was made by the witness, does not relate to this case. She did not identify any specific person as having threatened her with a gun. And so it should not form any part of their consideration about this case.
Poor judge. He's just like, can we not have a mistrial, please? Can we please not have a mistrial?
The DA has been trying to get everything. But
go ahead. I didn't hear you.
Yeah, the DA has been trying this entire trial to get, look how bad this guy is with this. Look how bad this guy is with this. And now he even admits during this talk that it's irrelevant to this case.
Yeah. Because they've got in to show that the daughter is an honest witness. They've got in information about this marijuana growing operation in the house, and to show that this guy might be a bad guy. He has a they allegedly opened the door, but now they get in that he had an unregistered firearm, and that's all they needed to say. He has an unregistered firearm. And then it goes off into this big thing. And now we've got to come to an agreement. What do we do? Do we strike it or do we have a mistrial? That's kind of what it's boiling down to right now. That's what they're arguing about.
Moving the goalposts in order to move the goalposts.
Would be
right
to not only give that instruction as to however many questions it was, but also because there's a serious slippery slope taint here, suddenly introducing a firearm.
It's slippery taint. I don't like that.
And to prohibit them from arguing about the firearm in their closing. Even though it's apparently some of that.
I don't want to get into a negotiating session and try to handcuff the district attorney. Either you agree to it or not.
Well, let's
and we'll talk with Mr. Barth.
We'll confer.
And I will tell you, as I said a moment ago, one of the possible outcomes of this is a mistrial. I'm not telling you it will be. I would sleep on it before I make a decision like that. And I probably wouldn't want to do a cram down on anybody either, but be aware, you may end up there.
Understood. We'll confer.
All right. If you don't mind the jury's overhearing what you say. No, they're yeah.
All right, so now the jury is going out. I mean, the jury's coming back in. This is such a mess, really. These two sides really honestly hate each other, I think.
Yeah, there's a lot of contention.
And let's see. Well, the fact we don't have a mistrial, obviously, so it does come to a conclusion. This big argument does come to a conclusion. Let's see. Chandler, you left before it came to a conclusion, didn't you?
Just shortly, but I did watch the rest of the feed, so I caught up.
What was the resolution? What did they eventually agree on at the end of the day to avoid a mistrial? Do you recall?
Oh God. What did they agree on specifically? They agreed that they were going to. You know what? I actually can't tell you exactly. We should probably watch it.
Well, we're getting down to the final minutes here, and I don't know if we'll get to the actual end part yet or not. There's like 20 minutes left.
Okay. Well, essentially, what I recall is that defense did not want to, to have a mistrial, and Joe had a lot to say about that yesterday.
Well, I don't know what Joe said, but the reason I can see they wouldn't want a mistrial is if there's a mistrial, he goes back to jail for another 6 months to a year at least. And during that time, the defense gets another chance to undo all of these mistakes they've made and correct all of their bad arguments, and to certainly be more careful about who they call as witnesses, etc. So I don't blame the defense for wanting to go forward. Nicholas, do you have any thoughts?
Yesterday, my initial thought was like Joe's, how the freak does this not amount to a mistrial? It has been borderline mistrial on numerous occasions. But your argument is compelling, that they don't want it because the next time everything will be, with a new jury, will be polished.
It's not double jeopardy. It can't be double jeopardy. There has to be a decision made first.
Right.
There hasn't. This is already the second trial. There was already a mistrial, and this is the second trial. Double jeopardy would
require an acquittal. What you're thinking of is a dismissal with prejudice.
Yeah, if it's dismissed with prejudice, that's different. Yeah.
Double jeopardy requires an acquittal. Now that I'm thinking about it, so basically I think that what ended up happening yesterday, now that I've had a moment to process, I'm pretty sure they agreed that they were going to stop questioning this, was that they didn't have any more questions for her, that they were just going to leave it as it was and to not get into anything else with her. So they just like ended questioning with this witness specifically. And they were just going to do a curative instruction to the jury, and no mistrial, and just moving forward, basically, was the resolution, as I understood it. So both sides agreed to that.
Steve, you made a comment in chat. Elaborate on that, good sir, if you don't mind. Okay, a mistrial charged to the state could be double jeopardy. Could be. It was charged to the state last time as well, and it didn't result in double jeopardy. So that's the thing. The last time it was for it could almost be the same thing. The mistrial in the first trial was because the defense did not turn over specific information to the defense as they should have. And maybe that's what the argument here would be, was that they didn't turn over the information about the fact that the gun was in Wisconsin at some point. But anywho, yeah, it's rough. It's a rough call. And again, regarding my theory, my thoughts that it would put him back in jail for another year, and it would give the DA time to correct his mistakes. Steve says, Jeff's right. Difficult question. RE defense asking for mistrial. It's not an easy decision.
No. Joe thought that they should ask for a mistrial so that they could put it on the record, so that, in the event of an appeal, it was preserved, which I understand. And I don't have an opinion about either way because it's not my area of expertise, but I thought that it was an interesting point.
Yeah, and for those of you in chat, I do. It's like weird. I have this thing where the more I try not to do something, the more I do it. So the more I try not to flip the words prosecution and defense, I end up actually doing it more.
I do that sometimes too. Yeah, it's like you could remember all of the finer details and make very concise arguments about specific things, but then your brain flips those two things.
Legal Vices was saying this stuff didn't need to be disclosed to defense. Legal Vices wasn't saying this. Somebody else must have been saying this. Legal Vices wasn't saying that.
Yesterday, a question came up about whether it was a Brady violation to not have disclosed what was discussed about the supposed unregistered firearm. And people went back and forth about that for a little while. I believe that, who was it? Somebody, Rob chimed in. And my understanding of it is that a Brady violation refers to exculpatory evidence only. So if the prosecution refuses to hand over exculpatory evidence, which means evidence that could exonerate a defendant or could possibly impeach the character of a witness for the prosecution, that
Joe was saying
that's a Brady violation. But there was a little bit of debate about that because there was something about I think somebody might have mentioned it in the chat, like inculpatory evidence being relevant as well. And because I haven't been to law school, I can't specifically speak to that. So it's possible that that there are other elements of Brady violations. I'm not sure. But a Brady violation was not brought up in court. It was simply being discussed in chat.
Well, we are we're running on borrowed time at this point. Let me burn through these remaining super chats so that we're clear and we start this trial new, and then we can go back to our discussions. Let's get rid of the judge here momentarily. Nunya Bitness. I see that. Is the state required to share this info with the defense? Certainly anything that would prove to, what's the word I'm looking for? My English is failing me. I've gone full Korean. That exonerates. That's the word I was looking for. Any evidence that exonerates the defendant, the prosecution must turn over. And the
gun stuff doesn't exonerate him. The gun stuff makes him look bad if the gun is his, essentially. I think the problem that you get into, it has to do with the way that the DA argued it. He said that they didn't think it was relevant, and I can genuinely see that being feasible.
Yeah, there's the relevancy argument. Where are we at here? Kim A says, during the ASL issue, we already read that, didn't we? Yeah, we already read that one. Sorry. You got a twofer. I think the attorney issue is huge. They could have told her the massive repercussions if she got on the stand and spewed out lies. Clearly no one did. Not well enough, apparently. Alyssa Ramirez, in my opinion, judge's curative instruction makes it seem like the girl was lying.
Well, no, he actually said that he said not to say that she's being dishonest. I believe he included that.
I mean, there's no clean way out of this. No. There's no perfect way out of this, but whatever the lawyers agree on is essentially what the judge is going to do. And so because she was lying, others are saying that too.
I mean, it all depends. The jury could very easily see her as lying, like it depends on how they interpret her. We're not seeing her face. We're not seeing her mannerisms. We don't know what the jury's thinking.
I mean, it should never have gone in. It did. And again, this is such a huge thing. There's no easy way out. Either she comes off potentially looking like she's lying, or he comes off as being impliedly, whether or not he did it, it's not been in evidence. And, it comes off and they're going to say, okay, well, obviously the father was the one that did it, and that's prejudicial. There is no easy way out. And the lawyers did what it took to avoid a mistrial. Nick Campbell says, if you slept after the bombshell dropped, I went back to sleep after about an hour. And Mandalore Wise, thank you so much for the big super chat there. Are there any judges that are more willing to order mistrial for state BS? If I were the judge, I'd have likely granted a mistrial with prejudice because the state appears unwilling or simply to make a clean. Well, the defense didn't ask for a mistrial. So, I mean, that's the first thing you got to ask. Noah's double jeopardy, Jeff. Judge said after the first day, I'd need a timestamp on that. I'm not saying you're wrong. I'd need a timestamp on that because you wouldn't know until it happens. Melissa, was Zach denied bail? This is breaded. Bail in a murder case is so unreasonably rare. Well, it's so rare. Yeah, nobody gets out basically. Torteo, obviously, Dad heroically stole the gun from Threatener. Lol. Okay. Yeah, the bail would be huge. It's the prohibitive bail. I mean, we get you get that the $2, $3, $4, $5 million bails and things just to make sure nobody's getting out. So, Nicholas, welcome.
Thank
Everyone
you.
needs to go to Nicholas Starov's Union Rep Labor Law channel and give him a good subscription.
Yeah, and please watch my content as well, because the last 100 subs haven't resulted in more views. So if you subscribe, great. But please, pretty please watch what I do. But not here, but on my channel.
Definitely do that. Get the view hours up. Get this
after
man monetized.
after the stream.
Or just let it run in the background. Yeah. And Chandler Remington can be found on Twitter at Remy REMY _legal right there. And also Natalie Wisco can be found at Natalie Wisco, NL Wisco on Twitter. And me, you can find me right here. So currently, what have we got going on? We've got 2,036 people, and I'm sorry, people, I'm missing super chats, and chat is flying by. We're gonna put this on like a 30-second slow mode, just because we've gone over the 2,000. It's kind of once you get over the 2,000 mark, it's a little hard to follow things for my elderly and boomerish eyes. This is not punitive. Nobody did anything wrong. Nobody's spamming chat. There's no sex bots. It's just to give me a little bit better chance at keeping on top of things. So if you got something to say it long form so you don't have to keep going back. Yet Tara Rayner says it cannot be unheard. Do they not get transcripts? The daughter's interview in full should be turned over. They don't get them instantly. This trial and charges should be dropped. I mean, it can if once you make the application, it can take days to get the transcript, or you can get it's not just coming out live speed. You need to be checked and reviewed and whatnot. So it will. I mean, they are going to be available at some point, but just not like instantly. You can. There are times when you can put rushes on them. You can get the preliminary transcripts and whatnot. They look up chat. Jeff, I see a doggo in the background. That's Strawberry in her usual place. All right.
I see that we are past the 2-hour mark.
We are, and let's bring this up here. So we're also 10 minutes late. The court usually seems to start somewhere around the 10-minute late mark, 10-15 minutes. And all right, we've got okay, Boomer. Thanks. I'll take that as a compliment now. I don't know why. I don't know why, but I will.
Get off my lawn.
Yeah. Okay. Well, Nicholas, these forays into American law. What are your thoughts on the proceedings from an outsider's point of view?
Oh, it's quite different because here we don't have juries. We have in the lower court we have 1 judge and 4 layman judge, and we have an appellate court with a panel of 3 or 5 judges, and then we have the Supreme Court with a panel of 5 or 7 judges. So it's quite different. We don't have juries in that aspect, and most of defamation in Sweden is a crime, so it's not a civil suit.
Mm-hmm.
And for instance, some difference is in the United States, truth is the absolute defense.
Yes.
In Sweden, it is if it's unrelated. For instance, there was a big case a number of years ago, more or less like the Amber Heard Johnny Depp trial.
Mm-hmm.
He said, she said.
Yeah.
And she was convicted. She got 6 months suspension and I believe some fines to it as well. And that was not because she lied, but because what she told was unrelated to the situation, just to paint this guy in a bad light. And he hadn't been convicted of it. No, sorry, he was, but that was like 30 years ago. Everything was passed. He hasn't been convicted since of anything like that. So yeah, here not even the truth is an absolute defense. So it's quite interesting to watch the U.S. Judicial system, and well, there's some differences. Just say that.
Well, that's interesting you said that. Talking about like defamation and slander in Korea, it's pretty similar. It's also a criminal offense. It can be a criminal or civil offense, but truth is not a defense. If you say something about someone specifically intended to cause them harm or financial damage, and actually do cause them financial damage, whether it's true or not, you can be found guilty.
Yeah.
Truth. Yeah. So that's why even if somebody does something really, really awful to you, you tend to generally not throw it around the internet and broadcast it, because they'll come after you. So yes, even though it is true, you said bad things about me to hurt me, and it did. So give me money. All right. A couple other things to burn through here. Welcome to the internet. We have Justin Smith asking, who is this Yanni Deep? Yeah. Hi, low 56. Does anyone know who was removed from court? Jeff said it was in chat, but never said out loud. Well, he said it was in the second row, and the second row of people was with the defendant's family, so it was one of them.
Well, I saw in the chat claim that it was the Sadie's new boyfriend, but I don't know the truth of it.
It was one of the, because the defendant's family was sitting in the second row, so it would have been one of them, I believe. Tara Rayner, I meant her interview about the gun in 2020. What was the question? I forgot. It can't be unheard. Do they not get transcripts? The daughter's interview in full should be turned over. The trial and charges should be dropped. Well, that leads us to, we got the judge sitting on the bench here. There's still no audio. We'll bring it up just in case. Well, that leads us to Steve Gosney's answer about the possibility of a double jeopardy mistrial.
That's good information to know. I wasn't aware of that.
Oh.
I always appreciate Steve's comments. Oregon versus Kennedy.
Hang on.
Look that up.
And to the chat, yes, I am Swedish.
Do people not know that you're Swedish?
Apparently not. I should
write. Let's listen to what's going on here.
Well, since everyone is silent, this red face is because I've been outside all day. I've been looking for...
Just in time.
He'll start today, but I think the materials have been turned over, and
just in time.
I don't know if typically the court clerk would contact him or if the defense has an obligation to do that. I just am not sure the protocol here.
Is this gentleman on sentence, or
he is
held?
He's being held on a federal detainer.
So he's been sentenced to prison here in Kenosha, and yet
There's no audio?
He will not be sent to prison until his federal case, which is a separate and distinct case, is resolved.
There's audio.
So his attorney is currently representing him on the federal case.
Is there any kind of an agreement or anything like that, or?
No.
As was the case with Mr. Washington? No.
No, not at all.
Is he going to be questioned? Anything with relation to his state or federal charges?
I intend to impeach him. I assume the defense would start to try to insulate as best they could, but I don't want to speak for them. But I intend to impeach him by asking him questions about his pending federal case. Yes, and his most recent case here in Kenosha has a high degree of deception in it. So a case he was just sentenced on here in Kenosha involves him having made arrangements through the jail to have drugs delivered in the jail, and then when caught at that, recruiting a different inmate and continuing a similar operation with a different inmate, continuing the deception after being apprehended. So, so there are certainly issues of impeachment that I believe are going to be logical and would be allowed to cover. Mr. Ahmad is aware that the defense intends to call him, so his attorney is aware of that. When I spoke to Mr. Ahmad today, and I think this is just an oversight by the defense, so I'm in no way trying to cast aspersion, but
She's like, what
Mr.
oversight?
Ahmad indicated that the investigator report that they have generated that has been shared with us has not been something he, as counsel for Mr. McAtee, has received. So I'm causing that investigator report to be emailed to Mr. Ahmad this morning. And I have a summary of, and this is just a prosecutor's summary of a number of jail calls of Mr. McAtee, which, again, this is just the prosecutor's opinion, but I think expose him to potential liability, depending on whether he says the same things that are in the investigator report. And so I've also sent that to Mr. Ahmad. But Judge, I guess the only thing I'm really trying to do is be sure that mechanically Mr. Ahmad is informed of what he should be doing, because he does have a calendar today. And if this witness were to go today, I could be the one who informs him if the court wishes me to. I just wasn't sure what the protocol was.
The reason I asked the questions that I did, he's subject to impeachment by fact and number of convictions. Generally not subject to impeachment for pending charges. And specific crimes not subject to impeachment, whether convicted or not, unless they relate to truth and veracity and are recent in time. And the importation of controlled substances into the jail would not ordinarily fit that picture.
Well, it'd be fraudulently done. So done in a way that, this is done by means of, and I'll
when you
preview
say
that.
fraudulent, to bring drugs into the jail, you would have to have some kind of.
It's not hidden under his arm or something like that. It's done through a deceptive practice, is what I'm suggesting.
Well, I'd have to hear you out.
I understand.
My point was, all this relates to whether we're going to break stride
just a little bit,
in order to accommodate Mr. Hamid's schedule. And so far, unless he's going to be asked about his pending federal charge, he's certainly welcome to have counsel, but whether he's entitled to counsel is another matter altogether.
Okay.
So if it's going to be any kind of a significant weight, I'm not terribly excited about it.
The only reason I'm bringing it up now is because I think Mr. Ahmad could be secured if he was given notice. So the only reason I bring it up this morning is so that we don't get to a point where we're there at 2:30 or 3. Again, I think there's a significant difference between the phone calls I'm hearing and what the report from the investigator is, but that's just my opinion. And so if the court feels that he doesn't need any kind of counsel in those kind of moments, okay. So I don't want to do it. I'm just asking for any guidance the court wants to give me on what to do.
Judge, I'll be handling these witnesses. And so, and I say witnesses because there's two actually. And I walked in late, so I don't know if you talked about recalling Mr. Washington.
I didn't, but the subject was mentioned.
Okay.
It was talked about.
Okay. So that's happening. As to Mr. Ahmad, I called him weeks ago. There was long delays, but finally he said, yes, go ahead and interview Mr. McAtee. So we did. And that was very recently, like in the last week, I think. And so he was fully on notice about, because he wanted to go visit Mr. McAtee before we interviewed, which is absolutely proper. And he did that. And then he said, go ahead and interview him. And we did. And we generated a report, which flatly contradicts Mr. Washington's testimony, in addition to some other items, which I agree with Mr. Gravely. We should probably air out with the court before that testimony to make sure that we know the parameters. But the whole jail call thing, I literally just got minutes ago. So, but from the summary I was given, it doesn't sound like there's going to be much there in terms of impeachment. But if there is, there is. But both of these, we've written both of these individuals. They're both queued up and ready to go. And I will call Mr. Ahmad myself to give him a heads up about, what time there might be if he wants to be here.
Did the state close?
And,
Rush?
generally when I represent somebody that's testifying,
No.
I try and be there in court with them.
Just
in case
step out of the room when I
there's,
come back and
anything
defense is talking about calling people.
especially
So
when I have a federal case. So I don't know how that's going to play out. We might not even get to it today, Judge.
If we
Given
keep talking about it, we won't.
okay, well then I just wanted to heads up about like how this all played out. So
Okay, the bottom line is this. I'm certainly not in any way suggesting that Mr. Hamid would not want to be here, nor would I suggest that he shouldn't be here or that his client shouldn't want him here. That's all fine. The point is, sometimes Mr. Hamid is hard to get a hold of. And you referred to that yourself. I don't want, this jury has already been prevailed upon to a great extent, and I don't want to extend their stay here longer than necessary. So someone should call Mr. Hamid in the next hour or so and alert him to the fact that when and if his client is within about an hour to an hour and a half of testifying, he's going to get the call, and we're not going to wait. He has to get in his car and come. And also, as I indicated, unless there are unique circumstances, he can be impeached on the fact of, well, you know the rules.
We have his
The fact and number of convictions.
We work with
in rare instances, pending charges. If there's any kind of a deal, then of course on the pending charges. Deal in consideration of any testimony, which I assume is not the case. And then under 90608 for specific instances, if probative of truth and veracity and the mere attempt or accomplishment of importation of drugs into the jail would ordinarily not suggest deceptiveness, but you might be right because you know about it and I don't. So, but unless it fits into the category of being probative of honesty or dishonesty and not remote in time, then that's not a subject of impeachment. So,
and if I could, Judge, if there's something in the possession of the state regarding whatever truth, veracity regarding this jail drug thing. We don't have that, and we would like that obviously as soon as possible if they intend to try and use that.
Yeah, I'm talking about the criminal complaint and so forth, but I'll provide any of those pieces of information to the defense, certainly.
Okay. Anything else?
Yes, just more of a matter of business. I have a federal case that they need me to call in at 10:30. So I was just hoping, I know we're getting a later start, but if we take one of our 10-minute breaks at 10:30, so that I can have that phone call.
That should not be a problem.
Thank you.
All right. Anything else?
No, we're ready.
I believe so.
Okay. When the federal date was set was
so
that was before this trial
it was
started?
before this trial, and
Okay,
it's the
you can't
trial's
say
being
anything more.
Yeah.
There are some people in all ranks of the judiciary, but federal judges are more susceptible to the temptation of thinking they can just make you appear before them.
Yeah.
Even though you have other matters, and
No, and we were supposed to be set for trial, and so it's getting adjourned because of this going late.
that's
fine. Yeah.
Okay. No problem at all.
And Judge, the court will recall Ms. Krazarek is going to do the electronic stuff that we're doing through Detective Korea, and then I'm going to take over. We're not going to do any intersection. There won't be a back and forth, and then I'm going to take over and talk about the investigative piece.
All right.
Okay.
I
Anything
have
else?
a better handle on electronics.
Nice.
Oh, very good. All right. I'm going to call the jury.
All right. So they were talking about
I'll probably call my wife.
a future witness who is apparently still in jail, who they need to make arrangements for.
Interesting.
Would you come down, please?
Okay.
Thank you.
Do we know who this witness is?
In my top
Someone who's going to contradict the jailhouse snitch is the one they're talking about.
There are numbered files.
They're going to have to make arrangements for later.
1, 2, 3, 4, 5.
For the, I'm sorry, for the state? I'm really confused.
No, the state, they have one more witness apparently, and then they're going to rest, and then the defense will probably start their case today. And they're saying he's one of the witnesses they'll need, and because he's apparently locked up, they need to make the arrangements to get him there. They're saying find his lawyer, and then they'll call him within an hour or two and let him know that he needs to come down to the courthouse.
Okay. All right. Well, I'm glad defense is going to start their case. I wonder how the prosecution is going to end. Do we know what last witness they're going to be calling?
Nope.
Well, that'll be interesting.
We'll see.
If he hasn't testified yet, then my bet is on Martin Howard.
Martin
the
Howard,
detective, the one who collected the receipts, stuff like that, the Walmart stuff. You guys had said he hadn't testified yet, right?
No, he did testify.
Right. Oh, he did? Okay.
Yeah.
I was confusing him with somebody else then. I was gonna say if he hasn't testified, then he's got to testify. So
yeah, he did. He testified.
Let's continue with this.
Detective Korea, here we go.
Okay.
You solemnly swear the testimony you are about to give in this matter will be the truth.
This is allegedly the last
this is
witness.
the guy who's been sitting at the table the whole time.
Please be seated.
This is their golden thread witness who's going to connect everything.
Detective, can you please state your name for the record and spell it?
Vicente Correa, Vicente, last name Correa.
Looks like you take this banner down now.
And how are you currently employed?
The City of Kenosha Police Department.
And how long have you been a police officer with the Kenosha Police Department?
I was hired in January of 2001.
How did he spell his last
What is
name?
your current rank at this time?
I am a detective assigned
With
to
a
the
C.
General Assignment Division.
Correa, I
And
believe.
back on
I'll double
May
check.
19th of 2020, were you also a detective at that time?
Yes.
And on that day, do you recall being assigned a case of a missing person of Mr. Gutierrez Jr.?
Yes.
And were you in conjunction with other detectives? Were you one of the lead detectives on this case?
Yes.
And as part of your role as one of the lead detectives, Were you responsible for reviewing a lot of the documents, downloads, video that came in as part of this case?
I was.
Chick Korea.
And were you, in conjunction with other law enforcement, responsible for sending out warrants and subpoenas for all those records to be collected before you reviewed them?
I did, as well as others. Yeah.
And so as part of your investigation, when the defendant was taken into custody, were you aware that he had 2 phones that were taken into custody with him at that time?
I don't recall if I was notified immediately of that, but at some point, yes, I was.
And you've been in court, obviously. Were those the 2 phones that were shown to Ms. Beecham, the ANS flip phone, which previously was testified to being 262-689-3585? Was that one of the phones?
Yes.
And then the
They
Moto
agreed not to
G6
question her
smartphone,
anymore.
which is 262-674-0529.
Yes.
And as part of this investigation, were those devices downloaded in the way that Officer Morton testified to yesterday?
Yes.
And are you familiar with the appearance of Celebrate reports that are generated as a part of those downloads?
Yes, I just want to back up to the previous question. The flip phone, I don't recall if that was actually like downloaded versus a manual download. I don't know if like a full type of extraction. I don't recall because of how old it was. I don't know if he was able to do a full extracting, so it was more of a manual type one, I believe.
So whatever download was able to be done was done on that flip phone?
Yes.
And I'm going to approach. The detective, can you make sure that TV is on? You had good luck doing that the other day.
Good luck turning the TV on.
Tech-savvy.
That's great. Well, while they're doing that, let's see how many of these I can burn through here. And Steve Gosney was mentioning whether or not it's double jeopardy. One of the issues is sorry to cover you up there, Natalie. Maybe you can comment on this too. Prosecutorial misconduct that was intended to provoke a motion for mistrial can bar retrial based on double jeopardy. So if it's just a random mistrial, it wouldn't be double jeopardy. But if the prosecution causes it, then it could be double jeopardy.
I did not.
You're muted, Natalie.
It depends, but yes, it can. If it is like that, they can. It can
Detective,
be.
I'm showing you this been marked as States Exhibit 315, which is a page from the Celebrate download of the ANS phone. Let me zoom in for a second.
All right, well, they're pausing here. So Sadie knows Zach threatened her kid with a gun, but kept on with him. She didn't even file for custody until after he was in jail for the crime. For this crime, yeah. People, these aren't some of the greatest people out there, you know. It's trying to find motives and reasons why people do things, particularly people that hate each other or love each other or hate each other, and they throw children into the mix.
On this document, do you see on 2/12 of 2020 where it says an image was taken, image 2020-02-12 at 9:53:27?
Yes.
And I'm going to show you now what's State's Exhibit 42. Was that this picture that was recovered from his ANS cell phone that we've shown multiple times during this trial?
I remember this one being on, or this photo being on the ANS. I guess I can't say 100% that was the actual image number, but I do remember that coming from the ANS phone, yes.
This is the one who's supposed to close everything together? I don't know.
I hope so.
So we talked, as part of this case, there was also then the Motorola G6 phone that you previously testified about. I'm going to show you State's Exhibit 311.
All right, everybody get off the anus phone.
State's Exhibit 311, which is
I also-
a Celebrate report from that phone.
I was trying not to
Showing-
giggle like a 4-year-old.
Got that Motorola G6 first had activity after being activated on March 1st of 2020. Is that consistent with your investigation in this case?
Yes.
So prior to March 1st of 2020, this phone did not have service to it at that point, correct?
Not that I'm aware of.
Now, fast forwarding to April 2nd of 2020, I'm going to hand you what's been marked as State's Exhibit 301.
I can squeeze one in here. Jacob's proud madre. We hear nothing. You do, because we fixed it. I was trying to listen to see if they were just talking or if they were talking about the case.
Which are web history
so I brought them
searches from the Motorola G6 phone starting April 2nd, 2020 at roughly 6:56 a.m. Is that accurate?
Yes.
And is it accurate that that first search on the top at 6:56:28 is for Amber Connect Magnetic GPS item Tracker Black AMB 362XLG from Best Buy?
Yes.
And then roughly 13 seconds later, another search is done. Spy Mini GPS tracking finder device auto car pets kids motorcycle tracker track.
Yes.
Then roughly 30 seconds after that, GPS tracking car charger, USB charger, and tracker with live audio. Accurate?
Yes.
Then at 7:01, Qubit GPS tracker, micro-sized GPS tracker with live audio.
Yes.
Then another Qubit GPS tracker quarter JPEG, so picture.
Yes.
Then back to the Qubit GPS tracker, micro-sized GPS tracker with live audio.
Yes.
Then at 7:03, mobile 200 GPS tracker with extended battery and live audio monitoring.
Yes.
Then at roughly 6 minutes later, 5.5 minutes later, links up mini GPS tracker, GPS tracking system.
Yes.
Then at 7:10, magnetic mini GPS voice recorder for vehicle, car, person, location.
Yes.
7:13 a.m., mini real-time portable GF07 tracking device, satellite positioning against the vehicle, person, and other moving object tracking at Walmart.com.
You say 7:13 or 14?
7:13.
7:13. Yes.
Then 7:14, Spark Nano 7 with magnetic water-resistant case for car, truck, or fleet vehicle.
Yes.
Then 7:14 a little later, mini real-time portable GF07 tracking device, satellite tracking. Is that accurate?
Yes.
7:15, 4G LTE Eon 4 long life GPS tracker for covert monitoring of teen drivers, kids, elderly, employees, asset, warehouse, tracks indoor and outdoor at Walmart.com.
Yes.
Page 3. 7:15, another Walmart.com tracker. Is that accurate?
Yes.
7:19, Moto Mini GPS tracker with 3 satellite positioning systems.
Yes.
Then 7:36, so about 17 minutes later, a website for top 10 best mini portable GPS trackers in 2020.
Yes.
Then 8 minutes later at 7:44, GPS tracker with voice monitoring, VJoy car GPS tracker.
Yes.
7:46, Wi-Fi Spy Mini digital voice activated recorder, GPS tracker, audio recording bug.
Yes.
Well, he clearly didn't buy the first one he
Spy digital
saw.
voice activated recorder, mini hidden audio recording device, 16 or 32 gigabytes on eBay.
Yes.
And 7:51, links up mini GPS tracker tracking system.
Yes.
Then 7:51, GPS vehicle tracking for fleets and
Yeah, these are
assets.
just searches.
Yes.
And then 7:53, mini camcorder locator X009 GSM, and a whole bunch of other numbers.
Yes.
And then 754, world's longest lasting GPS spy tracker at Walmart.
That's oddly
Four.
specific.
At 7:54 a.m., I got you GT 120 USB GPS travel and sport logger.
Yes.
7:55, 4G micro-sized GPS tracker, GPS locator online real time.
Oh my God, I'm going to use this riveting testimony to
GPS
be right
tracking
back.
device,
I need
GPS
some tea.
location store.
Yes.
And then 7:58, original real-time wireless listening device, mini activated recorder.
Yes.
And those searches all occurred on the defendant's G6 from 6:56 a.m. through 7:58 a.m.
Yes.
He sounds really good. I'm gonna follow Jeff's lead. I'll be right
Ultimately
back.
end up subpoenaing records from Amazon regarding purchases the defendant may have made during this time period.
Yes.
And when you received those records, did you see one of note on April 2nd that you thought was
Judge,
relevant?
I'm going to object. I was not provided notice that these certified records would be introduced at trial. That was the subject of my motion in limine.
Again?
So these are records subpoenaed from Amazon.
Right.
He's going to testify to the contents of the records that he subpoenaed from Amazon.
And I'm objecting because there's no way to authenticate these documents without certification and pursuant to the statute, and I can pull it up from my motion in limine, but it notes that if a party is intending on using certified records at a trial, that they're required to provide written notice of that, and not received written notice that they intended to use these records. As the court's aware, the amount of this.
Did you want to respond?
First of all, we believe we did give them notice, so we're checking that now from the prior time. But again, Judge, the court has had me read this stipulation a couple of times. These are
the objection she's raised is authentication.
right, and we're indicating that foundation and authentication are one and the same in terms of a stipulation like this to indicate that there's a separate entity. If you stipulate and say the foundational requirements to have various sets of records are stipulated to, one of those would be, in some cases, authentication or certification, right?
I don't know.
We're indicating that.
I never had the issue before.
If I may, though.
Hold on, Judge, we have a document.
And Judge, in addition to that stipulation that was entered into by the parties prior to obviously this trial on March 11th of 2022, there was a document filed, amended states notice and intent to introduce certified records at trial, which listed U.S. Cellular, AT&T, all financial records, all Amazon records of the defendant's purchases, Microsoft Corporation emails records for the defendant's email address, Google email records for the defendant's email address, and there's two different email addresses we used, and then we added Verizon phone records for Mr. Gutierrez. So that is a document that was filed March 11th of 2022 with our notice of intent to use these certified documents.
And it also referred to them to indicate to them that the certifications were in the discovery that has been provided, which was a large hard drive.
I don't have that in my file for this particular trial, but the obviously it stands as being noticed, so I withdraw my objection.
For you, Nicholas.
Does the court want us to tell you where that document is?
The frequency that these claims are made that discovery was not given is very concerning.
I didn't say
I'm not
discovery
singling you
wasn't
out.
given.
This happens in a lot of cases with a lot of lawyers. There were some cases some years ago, a number of years ago, quite a few years ago, where there was some faulty information got sent up to the Court of Appeals from another proceeding in another court, and ever since, there are wild accusations that are made in here. If you didn't get something, you'd better be sure that you didn't get it.
That's why I said I stand corrected. That was filed a very long time ago, and I withdrew my.
Well, she didn't get the last thing she thought she didn't get, so.
You want me to repeat the question?
I believe it was if I got Amazon records.
Yes.
Yes, I subpoenaed Amazon for the records.
And was there a purchase specifically on April 2nd that you thought was of note for your investigation?
Yes.
And what was that purchase on April 2nd, as best you can recall?
It was for 2 GPS tracker devices.
I'm going to show you first what's been marked as State's Exhibit 50. And so first, on the first page of this, here we have to zoom out. It's just this how the subscription info comes up for you regarding the records you were provided.
Yes, on the right side is just comes from Amazon. The right side is our case number. On the left side is on the top is their case number. Then the account information, the email address associated with that account, and then the purchases from the time frame, the address history.
Well, now Sadie had also said she logged on to his Amazon
For your
account.
investigation was this
and
6813
the
West
daughter
Highland
also
Road
had this
address
phone at some
associated with the
point.
defendant's residence at the time of your investigation.
Yes.
My entire family has my Amazon login info because they're all too lazy to buy
I'm going
print.
to show you this next page regarding order history. You see the one on the bottom that says order 114-9178995-1834630?
Yes.
And it has next to it quantity number 2.
Yes.
Does that then line up with the item description that's on this next page for that bottom one, titled Mini Real-Time GPS Tracker Car GPS Locator SMS/GSM/GPRS Network Tracker GSM Listening Device with Voice Activated Adapter?
Yes.
And then this next page of the document, does that then have just the price that was paid for those two things?
Yes. Yes.
And then for the order history on the bottom there, completed 4/2/2020, that's the ship date, correct?
Yes.
And it was being sent to that address in Mequon?
Yes.
Now, in terms of that piece of, or two pieces, two tracking devices that were purchased on the defendant's Amazon and shipped to his residence, was that then consistent with what's on State's Exhibit 254, which was previously testified to by Ms. Beecham of what she found in the defendant's Amazon purchases?
Yes.
And this also indicates 2 devices?
Yes, quantity 2 is this.
And do you see the delivery estimate date for this?
Yes.
And what is that?
Tuesday, April 21st, 2020 by 8 p.m.
Apparently, they found one still in its box on his table, so.
Was this before or after Sadie talked about Plan B with Junior?
That's a good question. That's a very good question. Let me see if I still have my notes on when they discussed possibly Plan B. I don't have those notes anymore. Dang it. Because that was, yeah.
Approaching with what's been marked as
It's a good question.
Exhibit 302.
I don't have the notes from that day anymore.
And if the time relates to when the daughter allegedly had the phone
history
and say they had a phone for a
Motorola
week.
G6
Yeah.
phone of the defendants from starting April 19th of 2020 at 6:19 a.m. Is that search for fitness and exercise equipment, best price guaranteed at Dick's?
Yes.
Then moving into short while later, a similar.
Judge, I'm going to object to relevance as to Mr. Anderson's seemingly routine purchases back in April.
Goes to the allegation that he had a back problem that was impacting his ability to commit this offense.
Yeah, because you certainly wouldn't want to exercise as a physical therapy or anything.
Well, does the purchase of exercise equipment of unknown nature date more or less likely, something along that line?
The defense has indicated through a couple of witness in cross that he had a back injury that caused him to be limited. We're indicating it did not cause him to be limited in the sense of being able to conduct or be interested in exercise equipment.
To murder, carry out, and hide the body of a 275-pound man?
Sure.
Unspecified quote back injuries.
Sure.
And Judge, this is also just a search, like a web search.
Correct, and then we'll have the Amazon purchase of equipment as well.
Yeah, I just don't see how any of that's relevant.
Well, why don't we skip ahead and see what was purchased? Because there are things that you might employ to improve your back, or you might have things that would. They have things on TV that I wouldn't.
You would call fitness equipment?
So I wouldn't be able to get up, I'll tell you that. But,
I can move on to it.
Did you buy one of these old exercise?
The shaker things. Boy, I wish we could skip past these. But in case you're wondering, somebody asked what today's tea is. Today I'm having some Dragon's Treasure Spirit Bomb tea. This has everything good in it. Apple pieces, blackberry leaves, lemon balm, rose hips, peppermint leaves, hibiscus flowers, natural papaya flavors, cranberries, safflower, and blue cornflowers. The Dragon's Treasure tea. Go order your tea, loose leaf, and tea bags. Use code VICES, get 10% off.
Amazon purchases. In your review of Amazon records, did you also notice an order the defendant placed?
Judge, I'm also going to argue for this order as it being not relevant and speculative as far as why it was purchased, for whom it was purchased. Just not relevant.
I think that it's something you could tackle with your cross in terms of the extent of the officer's knowledge. Overall.
So as part of your search on Amazon, did you note a different order that had occurred? And I'm just going to read the order number so you can get on the screen. 114-4694393-4347465 for a quantity of 1. Is that accurate?
Yes.
I'm sorry, counsel, we don't know what date at this point.
Right, I'm working there.
Okay.
And on that second level, was it for a yes for all double D row handle cable attachment, non-slip handle, and 360 steel swivel optional?
Yes.
Are we learning anything of import?
And according to these records,
I just learned I can order double Ds with non-slip hand grips on online.
Via priority mail to the defendant's Highland Road address in Mequon.
Yes.
So what's the equipment?
You don't want my answer because I'm going to say double
No,
Ds.
And I'm now showing you what's been marked as State's Exhibit 318.
Can you show by sign language?
Given the description as read out loud in court of double D handle, cable attachment, non-slip, is this appear to be the item that was ordered on that date to the defendant's residence?
That's not what I had in mind.
It's the grip handle for a band you put over the door to pull yourself. Yeah, to pull yourself.
Gee, physical therapy equipment. That's
yeah. I tore my meniscus 2 months ago, and the first thing I did was buy a bunch of stuff that might have been useful. Most of it weren't, but
it's still in the box.
And still in the box. But the one, and then some. The cheapest ones was the 2 rubber bands I needed to train my knees, and then a bunch of other stuff that was way too expensive, and I am too lazy to send it back.
And
it might be
Unhung Hero said like about an hour ago, there's no audio, but there is actually now.
Exhibit 303.
Seems like an intimidation tactic, said Tara. Absolutely correct. I agree with you back
April 22nd of 2020 at roughly starting at 7:34 a.m. At that time, does it appear the G6 is on or searching Facebook?
Yes.
And jumping down to this one here of 7:34 a.m., do you see where it says Reef Point Resort Facebook search?
Yes.
And was that a location that, as part of your investigation, became a place you were familiar with being associated with any particular person in this case?
Yes, it was a location where Sadie Beecham would visit or would go to.
So, moving on to the next page, 4:22 at 7:35 a.m. Is that again a search for the Reef Point Resort Facebook search?
Yes.
And then at 7:36, another search in that same general area.
Yes.
7:37, same thing.
Yes.
And going down here at 4:22, does it appear that, I'm sorry, on 4:22 at 7:50, are the searches now appear to be specific people?
Yes.
So a Spencer Knodl, K-N-O-D-L, a Dan, same last name, Sam Hagedorn, and then back to Dan Knodl.
Yes.
And these are all searches on his phone?
Yes.
Now moving on to 4:22 at roughly 7:51, is he now searching Sadie Jane?
Yes, here's the next 3.
And who in this case's Facebook profile, if you know, was Sadie Jane?
Sadie Beecham.
And then 7:52, there's some mobile uploads. Is that accurate?
Yes.
Then looking at Sadie Jane again, more mobile uploads.
Yes.
And then looking at Sadie Jane again.
Yes.
Before looking at Dan Knodl again.
Yes.
And then the Reef Point Resort again.
Yes.
She's making those head movements and shit again. See, dude, get her out of the courtroom.
Her body language is not.
Yeah, she keeps doing that. She takes off her earphones in disgust. Come on, Sadie.
All right, now approaching with State's Exhibit 306. Download from the Motorola G6 phone regarding installed applications. On 4:22 at roughly 4:15 p.m. installed on the G6, is there something called voice recorder?
Yes.
And on April 30th of 20 at 2:48 p.m., is there a installed application for Google Find My Device?
Yes.
Why was the fact that a voice recorder had been installed on this phone relevant to your investigation?
There were accusations made by Ms. Beecham that she felt as though Mr. Anderson was listening in on her conversations, knowing what she was talking about, and tracking her as well.
And why was the fact that Google Find My Device, why was that relevant to your investigation for finding it on the Motorola G6?
There was a point where Ms. Beecham indicated that she had felt as though she was being tracked down to Kenosha.
And ultimately, were Google Find My Device snippets found on the MSI laptop?
Yes.
And this was downloaded April 30th, that's accurate?
Yes.
And this phone had been activated March 1st?
Yes.
Maybe he has a tracking device because his daughter keeps stealing his phone. That's a good one.
That's my favorite one so far.
Oh my. All right.
Investigation.
Oh, never mind.
The
Psych.
evening of April 24th into the early morning hours of April 25th become relevant to portions of your investigation.
Yes.
Why was that?
During interviews with Sadie, as well as
The child?
and the daughter in common with the defendant and Ms. Beecham, they had both.
Hey, Cool Frog
had
Raiders,
indicated
welcome.
separately that,
Hit that like button.
At that night,
Thanks.
Sadie had Mr. Gutierrez was actually at her residence, and there was a point in time that night that her doorbell rang, which would have been the early morning hours, and she had observed a dark black vehicle that basically speed off from the residence, and she believed that that person was, or that vehicle belonged to Zachariah, or the defendant, sorry. And Olivia had also provided information to us on the evening of the 19th when we first interviewed her that that she was with the defendant at that time, and they actually did go to the residence, look through the windows. They had a phone with them, and that the defendant was recording at that time.
She didn't say
Approach you with what's previously
by
been marked
in her
as State's
testimony.
Exhibit 307.
She said she saw a black car pass by.
Yes, you are correct.
This is concerning phone contact between the defendant's ANS flip phone and his Motorola G6 phone, so between his two phones. Directing your attention to page 2 of this document, about halfway down. You see on April 25th of 2020 at 1:50 a.m., a text that comes through that is the following, and this is from his ANS phone to the Motorola G6, BAZT26. I can zoom in.
Yes, I know. Yes.
And is that string of 6 characters relevant to this investigation?
Yeah, so that is the Colorado license plate, which was on the Ford Explorer track vehicle belonging to Mr. Gutierrez.
So let me pull up State's Exhibit from State's Exhibit 1, picture number 1. Counsel, you would probably have it zoomed in. Just direct your attention to the screen. Is that Mr. Gutierrez's truck?
Yes.
And
That's what Nicholas
Does the license
thinks.
plate reflect BAZT26, consistent with
It's
the
his
message
mom's
between the
car.
defendant's phones?
Yes.
Mm-hmm.
And that's not a cheap truck either. Someone has loads of money and still owes
And I'm
a
going to
lot of money.
approach with State's Exhibit 304.
It's a good point.
This is 304.
How could you afford that car? Dunk, dunk, dunk. Give me my money. Dunk, dunk, dunk.
Oh. Bills come due.
So just looking at starting April 24th in the afternoon, are there a number of different searches on the defendant's Motorola G6 for the Find My Device tool that we've previously talked about?
Yes.
So going down to now 4:25 of 2020 in the early morning hours, 1:13 a.m. Is there a search for run a free license plate lookup and car plate number search on InfoTracer?
Yes.
Is there then a search that's done for BA, looks like 7Y26?
Yes.
Then run a free license plate lookup search again on InfoTracker?
Yes.
And on page 2 of this document, free Colorado license plate lookup.
Yes.
Did anyone in this case have a Colorado license plate that we should be interested in?
Mr. Gutierrez.
And then at 1:15 a.m., license plate record search.
Yes.
1:16 a.m., once again, free Colorado license plate lookup.
Yes.
And the search for search Colorado license plates for free. At
Yes.
1:16. Then reports for plate number, once again, it says BA7T26 in Colorado, United States.
Good question.
Yes.
And then continued searches for Colorado license plate lookups.
Yes.
Then do we show on page 3 of this, or the third page of this document, at 1:18 a.m., Department of Revenue motor vehicles,
Yes.
a couple of searches there, and then vehicle record searches, Department of Revenue.
Yes.
Still wondering when the daughter had the phone, if that was around that date. If she doesn't know the guy, and she is a nosy kid.
Right. And she wouldn't have the money to pay for a license plate search. It's a very interesting question, the timelines here. When did the wife have the phone? When did the girlfriend have the phone? When did the daughter have the phone?
Well, and not just that she didn't have the money, but you have to search for that stuff with cards. Most 12-year-olds don't have access to credit cards. Well, at least maybe that's a wrong assumption. My belief is most probably don't.
And going through the phones, were there also
Sounds good to me.
image results for some of these Google searches that he had been performing on that website?
There was.
If she can steal phones, she can borrow credit
We're just going
cards.
to show you what's on State's Exhibit 1.
She did count her dad's money and go through her mom's phone. She was pretty nosy, so I can't imagine going through a wallet, picking out a credit
guess
card.
that's true.
I'm not saying she did that, but
More of it, yeah. I forget how those additional facts is that.
And is
Who knows?
this a Colorado license plate lookup Google search that was recovered from his phone
Yes.
from the early morning hours of April 25th?
Yes.
I'm going to show you on the same State's Exhibit number 339. Is this
Oh my
another
God!
search that was done in those
It's
early morning
Gutierrez.
hours
He's
for
coming. He's
specific
coming through the
Colorado
door.
DMV?
Yes.
Yeah, I know I'm speculating, but so does the state.
All right, Flux said I'm in a Twitter war with a troll. Chandler is awesome. Chandler is officially welcome to the internet. LMAO. I love calling out stupid people, and also the Twitter troll doesn't
Love
want
you,
to play
Flux.
with me.
Oh, that's too bad. Thank you so much. You're a sweetheart. Love you.
Toodly Pip, new member.
Flux is the best.
Thank you, Toodly Pip. Flux is awesome.
Marked 314, which is another Google search recovered from that G6.
Maybe.
In the early morning hours of 4:25, was there this Google search for Eugene was typed in as Payerson?
Correct.
That returned results for a Eugene Patterson.
Yes.
And in this investigation, was there anyone with the name Eugene Patterson that you found relevant for this to be a piece that you were interested in?
Yes. So that was the stepfather of Mr. Gutierrez.
Okay. And?
I saw a chat if they can't put up a record of him how to dispose of a body, then
Yeah, hasn't been any of those searches yet.
Yeah, and I mean, granted, I don't have kids, but if I had kids, especially, well, I can't even say especially, any kids.
Was that search
I mean,
for
I
that
kind of would be
name
curious about the
relevant
people who are
given this
spending time with
document?
them.
Yeah.
Yes.
Yep.
And what is this document?
That shows good parenting.
Picture to the best of your knowledge.
Well, especially if it's somebody who's like a grandparent, something like that. It's spending the night at grandpa's house. Well, it's like if I don't know anything about grandpa, if there's publicly available information about it, I'm going to use it.
Okay, this is interesting. So the pink slip to the car is registered to Eugene Patterson. He searches Eugene Patterson
And
to see who the
during
hell
your
owns the
investigation
car
in this case,
that the
was
father of
Mrs. Patterson
that
able
my
to
girlfriend's new
provide
guy is
to you,
driving.
What she believed this full document to be in respect to this case.
Yes.
I'm going to show you what's previously been marked as states 225. Is this a copy of what Mrs. Patterson had presented to you as what would have been in Mr. Gutierrez's car during that time period?
It is. I don't know if it was provided directly to me, but ultimately, yes, I did see it and knew it was from her, which she had provided.
how does she know? Dating for 3 months and she knows what's in the glove compartment.
She's nosy as her daughter is.
Well, daughter had to learn it from somewhere. And see, it makes sense for him to be nosy too. He knows, okay, this guy named Gutierrez is hanging around with my kid. What do I know about him? Let's run a license plate check. Oh, wait a minute. The car is registered to some guy named Patterson.
I'm approaching you with
Who's this Patterson guy? You Google search for him.
308.
No, it's only okay for moms and daughters to be nosy, not
Oh,
dads.
okay. All right.
Yeah.
Sorry. My mistake.
Well, was it established that he obtained this information by breaking into the guy's car? Is that
The daughter
video
said so.
files that were observed on the defendant's phone April 25th, 2020. Is that accurate to the best of your knowledge of what this document is?
Yes, the updated video files, yes.
And the bottom 4 have been deleted. Is that accurate?
Yes, on the upper right, you see the deleted column, and then the 4 on there are all marked. Yes, 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 yes.
And were video files with those same names later recovered on the MSI laptop, if you're aware?
They were.
So the 4 that have been deleted from here had been transferred to the MSI laptop?
That I don't recall specifically.
Now, the top two videos, you've been in court obviously this whole time. Were those the two videos that were then played for Ms. Beecham regarding the overnight hours of April 24th into the 25th?
Yes.
And those videos were recovered from the Motorola G6 phone?
Yes.
I have tracking devices on my farm equipment, so I'm praying that somebody doesn't go missing around me.
Yeah. Lainey asks, what type of tea are you having? I'm having Spirit Bomb tea from The Dragon's Treasure.
Now I'm going to approach you with what was previously marked as which is marked as Defense Exhibit 297.
And while she's doing that, Greg Hansen says, why are they wasting time with the rest of this trial after yesterday's debacle? Can't they just skip straight ahead to the guilty verdict? I've still got hope. I've still got hope the defense is going to put on a good case.
You were present in court yesterday when Officer Morton was testifying.
Hi, Natalie.
Regarding this highlighted top one of, which says timestamp of 4/26/20, 9:29:52 p.m., where it has the coordinates being at the defendant's residence.
Yes.
And obviously there's no end time to this. Is that pretty clear there?
These are the end times.
So in terms of, obviously, Officer Morton testified regarding location data versus physically being there. You were here for that?
The state they are, yeah.
And so he said he couldn't actually say that that's where the phone physically was.
Correct.
So I'm going to show you State's Exhibit 320, which I don't know if you see.
Speculatively, that's why they didn't put up an actual expert on this. Because that expert could have testified more about location and the probabilities.
Yeah. Well, let me use this here real quick. So when there's a break, we can take advantage of it. Tara Rayner, BS broadcast the chance for more jail time if you testify. The DA is shady AF. Listen to his calls right before the defense case in chief. Sickening.
And so when Officer Morton testified, he talked about if you had looked up a location, it could give you a location, but you wouldn't necessarily be there. Is that accurate?
Yes.
Okay. And to your knowledge, Mr. Gutierrez Jr., because these are from his phone, he had his location data on all the time.
Quite often, yes.
Okay. And so I'm going to show you State's Exhibit 320, the second page. First, we will look at this one right here that says navigates. So that is the same coordinates that showed as Mr. Anderson, the defendant's residence, for just the time period of 9/29/52. Is that accurate?
Yes, and the address is, I guess it'd be so you have the coordinates, and then to the right of that, in that column, it says Highland Road, 6513 Mequon, Wisconsin.
6813 Mequon?
68, sorry.
And below that, it says source is Waze.
Yes.
What is Waze, to the best of your knowledge?
It's a like a driving or a GPS type app, so you can punch in an address, and it's similar to like a Google Maps or they use for traveling.
So if you were searching for an address in something such as Waze, that's a way you could search for a physical address.
Yes, you could use that app, yes.
Okay. And so I'm going to direct your attention to the column below that, which gives a different set of coordinates than the one above it. Instead of 43, it's 42, and then it's slightly different in the negative 87 point whatever. As part of your investigation, did you run what those coordinates were, the one below that, which the time says it starts on 4/26/20 at roughly 6:55 p.m.?
That's correct. And
did you run those coordinates through the map program to figure out what that location was at 6:55:07 p.m. that night?
Yes, that was Mr. Gutierrez's address.
Okay. And so on the vast majority of these, except for the one above it, there's also an end time that's associated with the location data. Is that accurate?
Yes.
So on this one that we're talking about, where you've indicated number 7 there on the left, that those coordinates are Mr. Gutierrez's apartment. Sorry, Carmen. Do you see that then there's an end time to that? So that the start time of that data says 4/26/20 at 6:55 p.m.?
Yes.
And the end time says 4/27 of 2020 at
Natalie had
7:22
something
a.m.
suddenly come up, so she had to take off.
So
She'll be
in
back if
terms
she
of your
can.
knowledge of cell phone downloads, from 6:55 p.m. on the 26th through the end time of 7:22 a.m. on the 27th, where that phone located at Mr. Gutierrez's residence?
Based on what it says there, the source is the iOS locations, which is the operating system of that cell phone, versus the source in the Waze, which is the app. I believe that the iOS location data shows that it's at the house during that time. Yes.
And when you say iOS location data, is that the operating system on an iPhone?
Yes.
And so is that the same data that's being used for all these other ones where it gives a start time and an end time of the location data? At least the ones we can see on this screen.
Yes.
So based on that, Mr. Gutierrez's phone was at his home the night of the 26th to the morning of the 27th.
The phone.
And now, obviously, you found that same address that we've just talked about, Mr. Anderson's address, in Mr. Gutierrez's phone in that way. So did you do any investigative steps in addition to figuring out that Mr. Gutierrez's physical phone was at his home to try to figure out if there was any way these two could have interacted?
During that time frame, I also looked at the ANS phone as well as the Moto G6 phone that we're calling here to find their location areas. And in doing that and putting them in, it appeared as though the one of the phones was at a location out in Thiensville area, and then the other phone was about 9 miles to the west of that. And ultimately, during that time frame, the phones come back together in the Thiensville area, and then that's where they remain. So at no point did I was able to see that either of the phones associated with the defendant were actually at the same location or on the address when Mr. Gutierrez's phone indicated that that might be an address or location where he was at.
And who in this case was living in the Thiensville area, if you can recall?
Ms. Renberg,
And
Christine Renberg,
And who was that in relation to this case, since it's been a while since we heard from her?
the girlfriend of the defendant at the time.
So even independently of the iOS data saying Mr. Gutierrez was home, you were able to figure out in your programs that the defendant's two cell phones were not home that night.
In the Mequon area? Yes.
This is apparently the state's last witness. Feral housewife said, why shouldn't he want to know about the man around his kids? Exactly. What, no Walmart in South Korea, says Vince.
As part of your investigation,
there were
you
Walmarts here
aware
before, but they went out of
allegations
business because
Ms.
they
Beecham
sucked.
had made regarding a phone being
True
planted
story.
in her vehicle on May 8th of 2020.
Yes.
And in general, what were you aware of were the nature of those allegations?
She had thought that she was being tracked down to Mr. Gutierrez's residence that night.
I'm approaching you with what's been marked as State's Exhibit 305.
Was that the incident where the daughter admitted that she was stalking the mom?
We need someone to lay out the timeline. Either it's accurate or it's not, because that
This is
is
web
confusing.
search history for that Motorola G6.
Judge, I just have to step out to make that phone call.
Yes, let's take our break at this point. Please don't talk about the case during the break. Read, watch, or listen to any account of the trial. 10 to 12 minutes, 10 to 15 minutes.
Which will mean it's like 45 Schrader minutes. Forward.
Yeah, we're on Schrader time right now.
All right, I will mute that. And wow, that's a good place to take a break here, because going way behind. We got 13 super chats to burn through here. Then we'll discuss.
Let's do it.
And one of them is a very interesting question, which you may also need the answer to. Don't encourage people. Don't encourage it. Don't encourage it. Okay. You may need the answer to this question too. Where'd it go? Where'd my chats go? Oh, there we go. Carpe Deegs, thank you so much for the $10 super chat. Off topic, tips for writing a personal statement for law school admission. Looking at an MLS with concentration in health law and policy. Thanks. My law school admission letter was written about 32 years ago. Anything I have to say is completely invalid. What I'm going to do, Carpe, send me a tweet or an email at thelegalvices@gmail.com or thelegalvices@Twitter. And when Natalie comes back later, who has graduated from law school much more recently than I, we'll ask her. I just know nothing about the current state of law school admissions to even begin to know how to address that statement. I didn't even know how to do it then. I just made shit up and put it on paper and somehow got in, actually, if you want to know the truth. But I will ask someone who may, in fact, actually know the answer to that question.
I'd love the answer. I'm currently in that same phase. So,
that's what I was thinking. You might need it too.
I've been looking into it, but I'm not quite at that stage of doing my application yet, and I don't know what I'm going to write for my personal statement. So it's a very good question. I'd also like to know the answer.
And thank you to the 2,416 of you that are currently watching this trial. The defense is wrapping up. Damn it. The prosecution is wrapping up. And the prosecution's wrapping up. This is their last witness, allegedly, after which the defense will start their case in chief. So welcome here for this. We're just in the middle of this 10-15 minute break, which if they're on Schroeder minutes, it could be 20-25. And while you're here, there's about 1,000 of you that haven't hit the like button. So you've all got plenty of time. The 1,000 of you have time to go down there and hit that like button. Let's get us up to 2,000 likes at least. That would be super, super cool. And while you're at it, the 2,422 of you that are here right at this particular second, if you're so inclined and haven't already done so, I would be just incredibly honored if you would reach down there and also subscribe to the channel. I am at exactly 35,700 right now. So thank you so much for that. Let's see if 300 of you can get down. Let's see if we can get to 36,000 by the end of this show. That'd be awesome. Only 300 of you just need to get down there and hit that subscribe button, and then you can come back for more. The chat has been asking to go back and do the other case that's going on right now that everybody's talking about that I would be interested in doing. What people want is me to go and just do it like a morning one day and then the afternoon the next day, the morning one day, the afternoon the next day. So we may do that next, and we'll do other fun things as we go along. So please feel if you feel inclined, do me that favor. And while you're at it, go over to Nicholas Starr of Union Rep Labor Law, his up and coming channel. He's got a channel about 3 months old, and that is just the name of his channel right there. Go to subscribe to him and like every one of his videos. Some fun, entertaining stuff. And you can see he is one hell of a good guy because right behind him, he has books. He's got whiskey. He's got cigars. He's got knives. Or is that a sword up next to the humidor? There you go.
Ooh.
Steve's looking for something like that. There you go. He's a man after my own heart. He's got some. Let's play a game here real quick. It looks like I can't see. Do you have an Annock bottle back there? What are you?
Yeah, that was from the Friday. Let's get drunk as fast as possible, and I opened this at the beginning, and so this is what's left of that bottle. I also managed to open this somehow.
Somehow, what
and
is
this
that?
is what's left. Now I've had some of it after, but I believe that half a bottle of that.
There you go.
Yeah, and then somehow a bit of vodka disappeared as well.
and some beer.
And some beer.
And you've got cigars, and you actually, when you're not being labor law guy, if I remember correctly, you have started a cigar lounge club type place.
Yeah, I am one of the founders of Malmö Cigar Club, and been around for 8 years now, I believe. 70 members. We have a location in the middle of one of the major cities in Sweden. And well,
if you ever find your way out Korea, just up the street from me is a cigar lounge that my best friend and I started, Casa Habano. You're welcome to join me for a cigar. And then jump on over to Twitter. Go over to Twitter and subscribe. What do we do on Twitter? We don't friend people. We follow them.
We follow them.
And we follow them.
Yeah.
We follow Chandler on Twitter. It's Remy REMY_legal. Right. Get her there for her based takes. She's definitely on the man's side. We like people that stand up for men's rights. We like based women, unbreaded women. Chandler's one of them. So that's a little bit of our introduction that we've got going on here. And she is a paralegal. She is getting ready to take the LSAT. She's studying for it. She's made the unfathomable decision to become a lawyer. It's like my son. I want to be a lawyer. Let me wash your mouth out with soap, boy.
Everybody's warned me, and yet I think the problem is being too stubborn.
Yeah.
I'm going to do what I'm going to do. And I've always been like that. So,
All right. Well, looks like we got about 7 more minutes of this break here. So let's power through these. Were trackers found on her vehicles? I don't think any of them were actually. I think the only thing they found on her vehicle was his cell phone, if I recall correctly. I know they found one of the trackers in his house, still in the box. I believe he was working construction or had tools. Yes to both of those. Many tools, toolboxes have been stolen in Wisconsin. Could be putting trackers on those items. Absolutely reasonable. Peachy Keen, I'm going to have a happy birthday, Jen. I feel the need. Well, Peachy Keen, this is the remains of one of my effing Friday bottles. Cheers to Peachy Keen. Happy birthday to you, Peachy.
Happy birthday.
I'll give you a little half shot. Cheers. Welcome to chat. Thank you for being in chat. You're great. We'd love to have you around. And it's a pleasure to know you. Cheers. Or you can do it the Nicholas way.
I didn't have a glass here, but then again, it's glass around the bottle is glass.
Sure. Don Musial, too bad Rosalio didn't swallow a damn tracker. We'd know where he's at.
That's a good one.
Sadie, short for sadistic, asks here for the truth. And Chris Catania again. How many stalkers take their children on their stalking expedition? That seems weird. You never know why people do things. That's trying to figure out why people do things. It just leads to weirdness and disappointment. Alyssa Ramirez, think the state will get to those murder charges? Well, I don't think so, because this is their last witness. I mean, the whole thing is he was here is proof that he was a stalker. And so therefore you just have to assume he would kill someone. That's the state's case as best I can see it. Flux, the troll won't play with me, but called in a friend. Living on Love, thank you so much for the super chat. I wish trolls would realize that even though we are speculating, so is the state. They have to prove he was killed or in fact dead, and they can't. Exactly. And as I've always said, you should not presume anything other than the fact that the defendant did not do it. That is the only assumption you should ever make going into a trial. And have the state convince you otherwise with the evidence that they present in court. Nothing else should matter in your assessment. Bad Weather Biker, thank you so much for the 10. I could honestly see Chandler Remington as the name on the office door of a noir private detective movie. Buzzing neon sign outside in the hallway window.
I love that. That's fabulous. Maybe you're thinking of like I feel like Raymond Chandler kind of when I tell people my name is Chandler, it's usually like, oh, like the guy on Friends, or did your parents love Friends? I was born before Friends even happened, so insulting. But one time somebody was like, oh, like Raymond Chandler, and I wanted to kiss that person on the mouth. So
good.
I appreciate that people think my name is really cool, because I think it's cool too.
And CHD says, legal advice is random. Would you support if a person takes on a public defender, that public defender would be given the same budget the state used for their case to use to defend the person? Oh, absolutely. The public defender's office, I would always support giving public defender's office more money and giving public defenders more pay. I would absolutely support any and or both of those options. John Basinger, the father was doing what a PI would do if the mom was about to be taken to court over child custody, right? Find out who the guy is, what he does. And D. Watt, about 16 minutes ago, said 420, blaze it if you got it. All right. Guests, what have you come away with this morning? Chandler, you first. What have you come away with this morning as the big takeaways?
I'm not really getting a lot from this witness. I don't feel like he's presenting evidence that's telling me anything that I don't already know. So I'm not.
But he's
sure
the big one
exactly
tying it all together. He's not making you go, oh my God, he really did kill this dude. You're not getting that feeling?
I'm trying. Here's the thing. If this guy was guilty, if he really murdered Rosalia Gutierrez, if he had stalked his ex, if he had done all of these things, he's a horrible person, put him away for life, fuck that guy. Like, I mean, honestly, I'm not here to defend somebody who's a murderer. I have not seen evidence. I have waited patiently for the state to prove their case. I'm not seeing it. Not with this witness, not with any other witness. So, sorry, I'm not getting there.
What about you, Nicholas? Where do you sit? How convinced are you that he murdered this guy and made the body disappear with no DNA transfer of any sort?
Well, I listened to the prosecution's opening and how they described the crime scene.
The sea of blood.
The sea of blood. And for you who doesn't know, I'm a farmer as well. And something I do is, not occasionally, but it has happened that I need to slaughter an animal. And if you miss the bucket, so to speak, there's blood everywhere. And a grown pig has just about the amount of blood as a human does. Don't ask me how I know that. I prejudiced. But it's a significant amount. You can't miss it. And when I saw that photo of the apartment, and they say, oh, the rug was missing, maybe all of the blood was there. Well, yeah, but if he rolled Junior in that carpet and dragged him out, there would be a 3-foot big trace out of the building, and it isn't. So I'm not convinced the guy is dead. And
a pig farmer is a convenient way to eliminate evidence. Okay,
I'm not a pig farmer. I have land, but a neighboring farm has animals, and we help each other.
Well, one thing I will say is that I've seen 2 bodies that have bled out, and the amount of blood in the human body is staggering. I mean, there's what, 6-7 liters? Is that about what we've got? So close to 2 gallons. Just take 1 liter, take a 2-liter bottle of Coke or whatever, and pour it out on your kitchen floor and see how wide it spreads, and then times that by 3 or 4. It's amazing the literal ocean of blood that you get when a body bleeds out. It is astounding. And again, I mean, how many times have you dropped just a cup of coffee on the floor or spilled a cup of milk, and it takes you for damn ever to clean it up because it just spreads out everywhere. So there is that.
I dropped a jar of salsa in my kitchen. It broke. There was glass and salsa everywhere. It looked like way worse than that crime scene looked to me. It happened like right after, and I was looking at the floor, and I'm like, I can't help but compare this to the crime scene photo. It took
was
forever to clean
chunkier.
up. It was, yes, it was a little chunkier.
Probably
But,
smelled
are
better,
they? The only thing that I can think, and it was sad missing all that delicious salsa, but the only thing I can think of is that their theory is that all of the blood absorbed into that little carpet, that was taken out of the apartment. I don't know. I'm not seeing enough blood in that room for somebody to exsanguinate to the point of death. You have to lose a certain amount of blood. I don't know exactly what that amount is, but I'm not really seeing that amount of blood in, for anybody who's seen Gone Girl, wasn't that like she's like took blood and saved it, and like to be that particular amount so that it looked like proof of death. I'm not seeing that.
Well, I think again, and it's what they made it sound like he bled to death. Mm-hmm. There's no way there's no way that looks like enough blood for someone to bleed to death. I think that may be their problem. You can die without all your blood going outside of your body. And I don't think that the prosecution made that particular argument. To me, it sounded like they were trying to make it sound like he was beaten so badly he bled to death, rather than you just get knocked around the head a few times with a baseball bat or something and you die.
They didn't make it very clear what they thought exactly happened to him.
Yeah.
They couldn't, they said that maybe it was a baseball bat. They couldn't really prove it. They didn't have a clear theory, which I think they should have put in their opening statement exactly what they think happened to him.
Yeah.
They could have put something together, because that's not evidence. They could have said that they believed that the defendant, went to am I incorrect that, they should have put, a story together of what they believe occurred.
Well, it should be coherent. Yeah. You should be able to figure it out just by listening to what they're saying and looking at the evidence. Unhung hero.
They don't have enough evidence, though.
A stalking case with a murder charge. Well, that was the other question. Hold on to that thought. Let me burn through these and we'll get back to that one. Kelly R. Starting to think Gutierrez is a parolee. No car, no job, no bank account. Wants to handle Anderson. I think everybody in this thing has been convicted of at least one thing or another. Boomer wow. Now that the Swedish guest is liquored up, we all have a feeling that Finland is awful, but we can't know why. Can you explain?
A feeling that Finland is awful? Finland is great. They are normally the only people I lose against in liquor wars.
They just have more darkness there than you do in the winter.
Yeah,
so they have to practice. No, my personal pipe maker guy, he's Finnish. Frost Pipes is the Instagram for one of the greatest pipe makers you'll ever find. Frost Pipes, what a guy. Miko's his name. He's a good guy. French Irish $2 super sticker. Thank you so much, Frenchy Irish. And Marv White. Did you see my email about 7 deputies, jailers arrested for murder in Virginia? It's a Virginia court, so if it goes to trial, it might stream. Yeah, the problem is just like from the time that things happen until they go to trial are just years, literally. This is 3 years. So it's going to be a while before anything that happens now gets near trial. But we'll keep posted. There's murders happening every day, so there will be no shortage of trials to cover. That's the cool thing. And as you can see, apparently we are running on SCHROEDER minutes, so we'll see how long it takes to get him back here. He should have been back several minutes ago, but we'll just have to keep on keeping on. Samuel Reynolds' daughter was tracking on desktop, not laptop.
Right. That's what she said.
Yeah. Jim Satala. Hey, thank you so much, Jim. Look at the timeline. It's all messed up. Exactly. I want someone to put together a coherent timeline to say who was doing what when. Where was the mom? Where was the daughter? Where was Zach? Where was the phone? The 3 phones. That's what I want to see. It's all messed up. These searches and purchases are a month after she claimed she was being tracked and gave his information to law enforcement officers. Yeah, this was all like, April 21st, I think was supposed to be the delivery date on the tracking devices. Alyssa Ramirez again. Oh, yeah, go ahead.
No. We saw this in the Murdoch trial as well, that the prosecution didn't really want to create the timeline speculatively, that they wanted the jury to fill in the blanks somehow.
Because it looks bad when you put it all together.
Yeah.
Yeah, Kyle Davis says the defense attorney had a meeting for a federal case on her phone. Yeah, she said it would be about 10 minutes. So the judge gave 15 minutes, and we are right at the 15-minute mark right now. Like literally right now. So the 10 minutes passed 5 minutes ago. The 15-minute deadline is coming up now. Alyssa Ramirez, question. If defense theory of case is cops didn't do their job, is one downside that the jury would necessarily play detective? Well, they shouldn't, because they're just supposed to listen to the evidence that's being submitted. You're supposed to analyze that and say, the cops didn't fingerprint the refrigerator door where the stuff was found. They didn't fingerprint the door handles. They didn't fingerprint the light switches. They didn't, check this. They didn't check that. They didn't do this. And they only focused on one guy. They didn't talk to any of these other people. They didn't consider the girlfriend. They didn't consider the two friends that mysteriously showed up the day that the crime scene was activated. So yeah, I hope the jury wouldn't go rogue and start playing detective. Just focus on the evidence and come back with a just and proper verdict. And one thing we can start doing now that the defense is just about ready to finish their case in chief, we can start putting up the do you think he's guilty, innocent, or hung jury type polls. I always wait till the prosecution has finished their case before I start doing those. Again, unhung hero, a stalking case with a murder charge, XOXO, J-Bear. And D-Flesh, reason for having trackers. Took our trailer to market our products in Texas. Someone stole our trailer off the truck in the middle of the night with everything in it. No tracker. $80,000 gone forever. Ugh, that just hurts. And how much blood is in a megapint? I'm going to guess about 1 megapint worth. That's going to be my guess. So, all righty. We can just, one more here. Julie O says, hear me out. Junior is at the resort in Mexico, and after this ends, that's where Mommy Dearest and Mouthy Kid are going. And there's been more blood in a menstrual cup than in that apartment. Thank you, Julie. Appreciate that image in my head now.
Yeah, I talked to my mom about the case, and her personal theory is that he's in his mom's basement the whole time.
Just hiding out.
She watched the mom's testimony, and she was just like, yeah, she's hiding something. Like, I think he's just living in the basement, just waiting this whole thing out.
Nick Campbell, it's impossible to make a coherent timeline without a coherent story from the district attorney. Well, you're true there. I agree with that. Legendary Racing. It's too bad this guy died / disappeared before the trackers were placed. Might know where he is right now. You all are stuck on him eating, swallowing, or taking what? What have I done? You keep swapping defense and prosecution. I know. And like I said, when I start making that mistake or other mistakes, the more I try not to make that particular mistake, the more I do it.
It's so funny that you do that, because I do that too all the time.
Ashley Cunningham says, I think the actual murderer testified against Zach. You might not be wrong. You might not be wrong. Why is Sadie so invested in this? Asks XCOMA Triple Z. In court every day, she has a new boyfriend. Scared he will not be convicted? Well, I mean, she is one of the victims. She's one of the victims here. And as soon as we get through this here, that's the next question I have for people. Julio, again, has anyone checked out to see if Junior is in Ozarks?
Be hard to find him there. It's a little
great show.
The terrain is a little
Okay, both of you and me seem to be firmly in the camp that the prosecution has not proved anywhere close to beyond a reasonable doubt that he, 1, committed murder, or 2, hid a corpse. Now, right. The next question is, do you think they have enough evidence to convict him of stalking? Because that's the other charge, the stalking charge. I'm going to say I would understand if a jury came back with a stalking guilty verdict.
Yeah, unless the defense can show something in, and that's something the prosecution has been going on for, what is it, 2 weeks?
3 weeks.
3 weeks.
Mm-hmm.
And the defense says they will be done on Monday.
Yep.
That's not a lot of time, but that depends if they have that prison snitch or two to contradict the other prison snitch, who is the prosecution's key witness.
Well, that's that's why I think they said that their one witness is going to be someone to directly contradict him. So they're going to apparently crush the prison snitch guy, and then maybe a couple of other witnesses is all it's going to take, I guess. Mad Lindstrom, another guy from up your way. What is that punishment for stalking? If I recall correctly from what Natalie said the other day, he has a repeat offender, which, I mean, doesn't mean he repeated this crime. It just means he's been convicted of another crime previously. And I believe she said it's a minimum 6-year sentence. I can't
No, that's for a class H felony.
Okay, and this is an I, so it was 3.
Yes, exactly. I think it was 3 to 4, and there's something about him being able to serve, I think,
85.
Some of that can
70,
be served with
67,
with probation. So it doesn't all have to be him being present in prison. Some of it is probation.
And he's already been in jail for almost 3 years, so he could walk pretty soon.
Right. So if they add time served, it's possible that if he's just convicted on the stalking charges, that he could walk. My opinion about the stalking charges is that I think it's possible. I think it's possible that so if the defense says that they're going to arrest on maybe Tuesday, I would imagine that they have a couple of really strong witnesses who they have a lot of faith in. I would hope that that's the case. And I personally can't figure out whether the stalking charges are appropriate, because there's that one blurry video where it seems like, he took it on his phone and he went into the house. A lot of the evidence seems to be from the daughter's testimony and her police statements. I don't think she's a reliable witness. I don't know if the jury is going to see her as reliable. The problem is that the jury could see him as being guilty about whether I perceive it or not. So I don't know. I mean, I feel like the daughter was, doing some of the stalking also. It's just not clear. It hasn't been made clear. So I'm hoping the defense is going to be able to clear that up, and we'll see. But if he does get convicted on the stalking charges, I think that would be perhaps appropriate, because it's possible that he did, engage in stalking type behavior. I'm just not certain about it.
Yeah, I could understand. I don't know if it's quite risen to the level. And just to very, very loosely paraphrase what the statute said, it's you have to do something knowingly that will knowingly cause the other person to be in fear of danger. That is very, very loosely it. And so I don't know if it's quite risen to that level, but I would certainly understand it if they came back with a guilty verdict. I wouldn't say that was a gross miscarriage of justice. I go, all right.
The problem is that the prosecution doesn't know how to handle the murder and the stalking in a way that they can balance them. And I feel like they haven't proven murder, and the stalking is really murky.
Yeah, the murder charges so far is there's a decent amount of blood, and he hasn't seen his kids. He hasn't contacted either of his girlfriends or either of the women he cheated on and with. However, that is evidence. I would take that as evidence more likely to him disappearing voluntarily, with all these women around, all these baby mamas around, all the alimony he's owing every month, relying on mom to have a truck, owing his co-workers money, apparently a lot of money.
The bank account, the joint bank account with his mother.
The joint bank account. I mean, if anything, that shows me if he was severely beaten, which that's the much of evidence I see, he was severely beaten and then disappeared.
Yeah.
And I can see that as more possible than him being murdered.
There are likely other people who wanted to harm him.
Yeah, or murdered by someone else. Yeah.
He owed people money. He, I don't know if he was involved in drugs. It seems like there are other plausible theories that the DA's office completely ignored. They did not look into other suspects for some reason. They really zeroed in on Zachariah Anderson. And that's problematic in terms of their investigation.
Yeah. Isn't there a theory that the criminal Isn't it a theory that the criminal returns to the crime scene?
Yeah. Well, yeah, that's why it's weird is she didn't hear from him for like a day. So she shows up and finds the crime scene. And then two of his friends who hadn't heard from him for a day, they mysteriously show up at the crime scene at the same time. So three people just randomly show up at the crime scene on the same day, right around the same time.
And
at the time at the time he might have been away. Nobody knew his schedule, so he might have been away on work.
Well, the first day he was making arrangements to meet the court clerk from Milwaukee he didn't show up for. Kelly R, thank you so much. Wait, he was allowed in the house and to do laundry? Am I wrong? Yeah, he didn't have his own washing machine. So he I guess he would do it over at Sadie's house some of the time, at least some of the time. And he stayed at the house at times. So stalking. Yeah, see, that's why I'm saying. But then he did do allegedly some creepy stuff that seemed to be fairly decently supported. So, like I said, if they come down saying he's not guilty of stalking, I get that. If they say he is guilty of stalking, I can understand that. I mean, whether I completely 100% agree with it or not, I could at least understand how they could look at the evidence and go, okay, he's guilty of stalking.
And if he's guilty of stalking, that's indefensible. I mean, that's, I don't think anybody here is saying that stalking is okay or stalking is a good thing.
Yeah.
I
just
think
not
the problem
murder.
is that exactly the murder charge kind of, it kind of overrides that whole thing.
And Julie O, but didn't they say that say defendant can imply another person did it? Like, how does that work? Isn't it part of creating doubt? Well, I mean, clearly the assumption is someone else did it. I mean, because if those are your choices, my guy did it or somebody else did it. And you can always say they didn't do a good enough job. So they didn't look at anybody else. They didn't look at this wide array of people. They only focused on my guy. But the problem is you have to do a special motion and give arguments and a notice to the prosecution that you are going to say, Nicholas, specifically Nicholas, not my defendant, Nicholas committed the murder. If you do that, then you have to make this in Wisconsin, this Denny motion where you say, okay, we're gonna point the finger at this guy, and here's the reasons why we're pointing at this guy. Then the judge decides whether you get to point the finger at a specific person or not.
Right. And they did file a Denny motion for one of the individuals who was a witness for the prosecution with the last name of Campbell. I don't remember his first name. They did not file a Denny motion in relation to Sadie Beecham. And when they brought it up in court, Judge Schroeder said, I would have considered that, after reading some of the texts aloud between her and her friend Rebecca, where, Rebecca said something like, you'll hear in a week, and it'll be taken care of. And then a week later, Rosalia goes missing. So they didn't file a Denny motion for that, and they should have. That's kind of the misstep here.
And C. Suitor, I feel like this is all legitimate searching. If you meet someone online, Sadie should have done all that herself. Yeah. I mean, well, as far as doing license plate checks and background checks, those make sense. Allegedly putting recording devices in, an air conditioning duct, looking in windows, following people around, that's when it gets shadier. But the searches, I don't have a problem with the searches. That's why we have these capabilities to do searches, so we can do searches like this. What do you got here? Prison snitch. What was that?
I was just going to ask, did they find a tracking device or a recording device in the air conditioning unit?
No, that was the daughter. She said that they put it in there. They made the video. Then he rang the doorbell, grabbed that, and then they drove away that first night.
Right. I was just wondering if the mom took a picture of it or something, if somebody found it, if there was evidence that actually occurred other than the daughter's testimony.
The daughter's testimony, and then I guess they took some video or audio through that as well. I don't know.
You would think they would look at the air conditioning unit to see if there was something in there, maybe?
Well, they didn't look at the fingerprints on the refrigerator door, so don't expect too much. P.G. Keen says, prison snitch was not believable anyway, so don't know why they have to impeach with their witness, because you want to make sure they know that he's... Because he may have been believable to somebody. Now you have to put someone up to show exactly the opposite statement. And I think he's going to be a good witness. But of course, he's going to be impeached the same way that they tried to impeach the prison snitch. You're a felon. What do you get out of this? You're not doing this out of the goodness of your heart. How should we believe you? You're a horrible person because you're in jail. That's how that will go. And
Our prison snitch is believable, not theirs.
Yeah, that's the other alternative. Yeah, well, our guy's not as evil as him, and especially if he's not getting a deal. All right, judge is back. Let's see.
I was approaching with State's Exhibit 305 with web history for the Moto G6 on May 8th. And I believe you testified that May 8th was the day that Ms. Beecham had indicated she had found a phone in her vehicle?
I believe I had indicated that she felt that she was being tracked down to Kenosha, but yes, she also indicated that she had found a phone in her vehicle, yes.
And so looking at this web history here on May 8th, is the last web history notation May 8th at 8:18 p.m. on that day? Is that the last one we see?
Yes.
And then is the next web history we have on this phone May 10th at 2:48 p.m.?
Yes.
And is that consistent with her reporting giving the phone back days later?
Yes.
That's what they're going to rely on. We'll talk about that in a little bit too.
Now, as part of your investigation, did you also subpoena records for email accounts of the defendants?
Yes.
And was one of those email accounts zjaii@hotmail.com?
Yes.
Hotmail? Jeez. 2,000 called. They want their email back. Does anybody still have a Hotmail address? I haven't heard of a Hotmail address in like 15 years. You do? Cool. You're muted and retro.
I have one that I use for to avoid the spam to my ordinary.
Hotmail.com to a couple of parties, Kristen Ellingsworth and Mark Levice, about an address changed by the defendant saying, I need to update my contact information. Under the circumstances, I will be forced to change my residence. As of May 15th, my new address will be 2040 South 92nd.
I guess I'm going to object. I'm going to ask that this exhibit not be taken down for reasons that this is going into previously covered information that was previously ruled on.
I can't see it, so I don't even know. I didn't hear what she was saying. But what's the document?
It's an email from the defendant to some parties regarding a change of address. As you'll recall, and Andrew Schultz testified that the defendant was going to be using his address in name only, and that's the address. So it's just tying up those loose ends. I'm not going any further than that.
It's okay if that's the extent of it.
That is the extent.
Aha. Hotmail is Outlook now. Ooh, then I use Hotmail.
Email about a change in address as of May 15th.
Yes.
And is that 2040 South 92nd Street the same address Mr. Schultz provided when he testified as where he lived, and an address that the defendant was going to be using in name only?
I don't actually recall him giving an address, but he indicated that he was going to move in with him, yes.
And obviously this says this would be the new address as of May 15th. When you interacted with the defendant on May 19th of 2020, where was he actually residing at that time?
In Mequon?
So not in West Dallas?
Correct.
Now, earlier in this case, the name Stephen Lenz came up. Do you recall that?
Yes.
And who was Stephen Lenz in your investigation?
He was an associate of the defendant, and he resided, I guess it'd be like almost like kitty corner kind of from Miss Beecham.
From her residence?
Yes.
I'm going to approach with what's been marked as 317.
Yes.
Wow.
To 317 on grounds that it contains hearsay.
Judge, I understand that the court doesn't love it's not for the truth of the matter asserted. It's between him and the defendant. And I'm more interested in how the defendant responds to the phone calls and the messages than the messages themselves.
Judge,
May I see the document, please?
Sure.
Okay.
Reports that it's not using it for the truth of the matter asserted. The state surely is going to be, Stephen Lenz hasn't testified. There's been allegations already about involvement between Mr. Anderson and Stephen Lenz. So I think that further makes it critical to not have this come in for reasons under hearsay.
Well, I've addressed before this idea that which number on the left-hand column, which number are you referring to?
This is the big debate: catty corner, catty corner, kitty corner, or kitty corner.
Yeah, well, you know, you can't see it. Yeah.
All right. Well, while they're doing that, we'll get. Anyone else find it strange that Sadie's location was off on her phone, so they don't know where she was on May 17th? Not particularly. I have my location services off on as many of my apps as I possibly can. I just don't want the government tracking me. Don't want to, don't want the Illuminati to know that I'm buying cheesecake from Costco. Tara Rayner, thank you again for yet another super chat. Did they ask Sadie how she felt about these other Facebook dating side pieces? Yes. She said she didn't know about it, but she seemed to be okay with it even if she had known, because they were still early in the relationship. Was Junior into any drugs himself? Possibly. I don't know. Tight on funds makes some do whatever needed. People were in debt in this case. You're right. But yeah, she had that side piece thing she didn't know about, but she said she might be cool with it.
At least one side piece.
He was supposed to be dating the court clerk from Milwaukee.
I don't know how it could escape being classified as hearsay.
Oop, you don't get that in. Whatever it was.
Yeah, no, and that is, how many times have I addressed that during the trial? That's used as a Trojan horse by lawyers, and they either intentionally or otherwise, that really fits into their logic. But the problem is that it hauls a lot of hearsay into the record. It's usually irrelevant. Now, if what you're trying to offer is a statement of the accused, and it's necessary in order to give meaning to the statement attributed to the defendant, then it would be acceptable in that case. But
I want to point out this is a specific part I'm talking about.
you can't whisper to me that.
Okay, so
Cheesecake from Costco is so good. It is, isn't it? Wonder if Sadie's new boyfriend is nervous, says Mandy Wright. She doesn't have a good track record. One ex missing dead, one facing life in prison. Yeah. Feral housewife. The defense can't offer anything to their snitch. That's true. So that's one of the important questions. So what are you getting at? Why are you doing this? It'll be interesting to see what the answer will be, because I'm almost guaranteed they're going to ask that. Why are you doing this? So we'll have to see. Tara again. Turns out the snitch isn't getting much of a deal. Oh, I hope that whole thing collapsed around him. I hope the feds went, yeah, never mind. You're going down for the full thing. Your testimony sucked ass.
Yeah, and meanwhile, everybody knows he's a snitch.
Yeah.
Congratulations, you get extra 10 years of people knowing you're a snitch.
Vince Clortho, can the defense ask for a directed verdict in front of the jury first? No, it's outside. It'll be outside the presence of the jury, and they'll make their motion after the defense rests. We'll probably hear it here in not too long, probably right after lunch, I would guess. Just guessing by the time frame. And Rob Pires says, is this another case where the accused should not take the stand? In my career of trial watcher, the accused always has taken the stand. If he takes the stand, he's an idiot. I would just let my lawyers do their job. He would be crushed I think if he got on the stand. That's just me.
I can't see him gaining anything from taking the stand.
Other than life in prison.
Yeah.
Yeah, I think if he does, he's incredibly, I won't say dumb. I'll say taking an incredible risk. Yeah, he's foolhardy. Yeah. Leave it with your lawyers. I think the case is weak enough that he doesn't have to. But again, it's him.
I'm sure his lawyers would tell him not to, but as everybody knows, if he insists on it,
if he goes full Murdoch and says, "I want to take the stand," there you go.
Mm-hmm. I don't think he's gonna. I don't think that he doesn't seem to me like a guy who has a big ego. I don't know, based on his body language, I don't know anything about him, but he wears his heart on his sleeve. You can read his emotions on his face pretty clearly, and I don't think so.
Michael says, "I'll say it, Jeff. He'd be dumb if he does." Okay.
I bet money on him not testifying, but I don't think anybody would take that bet, really.
Satellites can track your phone's location when your location is off, but not your cell service provider.
Yeah, I really hope the defense has that kind of an expert that can crush the investigators' opinions, because they are not sworn in as expert witnesses. They are just, this is what I believe.
It'll be interesting. I'll see how aggressive they are and what witnesses they choose to put on the stand. And I'm looking forward to the defense's case, because I don't think the prosecution has proven much of anything. Like I said, maybe possibly stalking, but that's it. So just see if the defense kind of pounds the nails into that particular coffin.
I mean, I've enjoyed the 3-ring shit show of it all. It's been a mess, but I'm definitely more looking forward to the defense's case.
Boomer Wow says a $2 super bet chat that he does take the stand, Chandler.
I'll take that bet. Definitely.
Oh well, let's take this. Let's take this little. Never mind. Nope. What are we doing?
Detective, I'm showing you Celebrate reports from the defendant's ANS phone to the number 414-378-4935. Was that previously testified to being Mr. Lentz's phone number?
Yes.
And on May 11th of 2020, was there a 3-minute and 2-second phone call between the defendant's phone and Mr. Lentz's phone?
Yes.
And then on 5/12 at 1:54 p.m., was there a 33-second call between those two phones?
Yes.
And on 5/14 was 2020 at 7:33 p.m., was there an attempted call that wasn't answered?
It appears so, yes.
And on 5/14/2020 at 8:08 p.m., was there a 31-minute and 52-second phone call from the defendant to Mr. Lentz?
Yes.
And then on 5/16 of 2020 at 8:31 p.m., was there a text from the defendant to Mr. Lentz saying she got another vehicle in the driveway ?
Yes.
And then directly after that at 8:37 p.m., so roughly 6 minutes later, is there a 6-minute and 43-second phone call between those two parties?
Yes.
Hey.
Now, as part of your investigation, did the date of May 13th become relevant given what had been reported by Ms. Beecham as concerning behavior by the defendant?
I'll be right back.
And what was the nature of the report to you that led you to investigate that day specifically?
Ms. Beecham indicated that she believed that the defendant had followed her to the Mr. Gutierrez's residence. You want me to continue or?
So I'll ask a follow-up question. So with that date in mind, did you spend time reviewing the phones to look at May 13th of the defendant's phones to see if there was anything of evidentiary value?
Yes.
Approaching you with what's been marked as State's Exhibit 313. these audio files that were recovered from the Motorola G6 phone of the defendants from May 13th, starting at 8:34 p.m. I can zoom in further. 8:34 p.m.
Yes.
And were all of these files actually found deleted on the defendant's Moto G6?
Yes, based on the column there, yes.
The far right column that says deleted all the way down?
Yes.
And what specifically about these audio files, were you able to recover these portions of the files?
I was able to listen to them, yes. I didn't do the recovery of them.
Okay. In your review of the
Yes.
download, were you able to listen to a file called 10, 16, 18, 24, 32, 34, and 36?
Yes.
And what about these files jumped out at you given that date and what your investigation was regarding these specific audio files that had been deleted?
So based on those audio files, they appeared to be directions from some sort of a mapping application. So if you were to use a mapping application to get you from, in this case, I think it was from the Mequon area down to the Kenosha area, there's I guess in this case, I believe it was like a female's voice that tells you turn left, turn right, type thing. So that's what these audio clips were. And it was also consistent with the time frame that led down to the point at which Ms. Beecham ended up receiving a text that she believed to be the reason why she felt that she was being followed.
And in these clips, is it the full GPS guiding you down here, or is it just snippets of it that were able to be recovered?
They're just snippets.
Aren't those files auto-deleted? They are implicating that the defendant
Regarding these audio
deleted
files
them.
recovered from that G6.
Don't know. Jeff K says, did Yoda take a Grumpy? No, that's a weird thing, but thanks for the $10. Thanks.
Some super chats are just kind of out there.
Hey, you pay, I ask.
$10,
I
$10.
answer. You pay, I answer. Whatever. No, that's not what happened at all.
What was that all they had for this? That was it? That's their big finale?
So we're going to start with what's in State's Exhibit 1, number 348.
Okay.
Still more. Okay. Shoo.
Are you guys getting anything out of this? Are we learning stuff?
I guess I can take this off now, can't I? There you go. No.
I'm like, you're learning anything, Nicholas?
Use the second from the left lane to turn left onto West Mifflin Road.
Oh, Jesus. Do we have to listen to this?
Unfortunately, it started before I had unmuted my, so I'm going to play it again. It's a 5-second clip.
Quarter mile. Use the second from the left lane to turn left onto West Mifflin Road.
Okay, so he was there. He was following.
Play what it was, State's Exhibit 1, number 349, which was audio file number 16 at 9:04 p.m. on the 13th.
That's interesting.
Wait, did you say 14?
It's easier to hear and understand
Quarter
female
mile.
voices.
Merge onto I-41, I-94 East.
Normally it's female voices that causes me stress.
Yeah.
Recording that's called number 18
Piercing.
on the G6 from May 13th.
Shrill. Get your attention.
We need to talk.
That was the best piece of evidence right there.
So when you talk about them not all being complete, is that one that kind of cuts off where you get kind of a snippet but nothing more?
It appears to be, yes.
Now this is State's Exhibit 1, number 351, May 13th, 9:19 p.m.
this might prove a stalking, but it has. I thought they would focus on murdering, but
Take the next left toward Wisconsin 31 South. Then turn.
I'll see if they would have had that whole clip. I'm sure it would have said, "Then turn and die, motherfucker."
Number 32, May 13th, 9:25 p.m.
The next left onto 12th Street, Summers Road.
States 1, number 353, from May 13th, 9:25 p.m.
You have arrived at the murder scene.
You on 12th Street for 1 mile.
That one seemed to skip at the beginning. I'm just going to play that one again.
You on 12th Street for 1 mile.
And then States Exhibit 1, number 354, May 13th at 9:28 p.m.
Quarter mile, turn left onto 15th Street.
So, Detective, did those sound like the same audio clips that you listened to from that Moto G6?
Yes.
And what about those directions was relevant to your investigation that caused you to think that they had some sort of evidentiary worth?
Well, they appear to be directions that would be possibly coming from, I guess, the north, coming into the Kenosha area. I know that 12th Street is Highway E, which runs east and west, and 15th Street is the Mr. Gutierrez lived at 3709 15th Street.
Hmm.
Now, I'm going to show you what's previously been shown as States Exhibit 1, number 323. You previously testified about it earlier today. You previously testified that this was a picture that was recovered from the ANS flip phone of the defendant. Is that accurate?
Objection has been answered. It's extremely redundant.
Well,
Yes.
and when best you can recall, or which day best you can recall, was this picture taken on that ANS flip phone?
I believe it was right around that time. I don't,
Right around what time?
right around the 13th. I don't recall the exact date, but it was right in that general time frame.
So right around May 13th, this
Yes.
photo was taken?
Yes.
Now, the last audio clip I played for you was from 9:28 p.m. on the 13th that mentioned 15th Street. Is that accurate?
Yes.
I'm now going to show you States 289. Detective, do you recall this map being testified to by FBI agent Hannah Judd?
Yes.
And what, in your recollection, does this map depict that is relevant to this investigation?
So on the far right side depicts where the cell tower is, and then it's basically opening up to an angle to, I guess it'd be to the west, and then there's the address of 3709 15th Street, Kenosha, Wisconsin 53144, which is the residence of Mr. Gutierrez.
And does this map reflect that on May 13th of 2020 at roughly 9:34 p.m., the defendant's ANS flip phone was somewhere in that vector connected to that tower?
Yes.
I'm now going to show you what's been marked as States 209, which is text messages between, the defendant on his ANS phone and Miss Beecham from May 13th. So at 9:36 p.m. on May 13th, is that where we see the text? Is this okay for right now, or is there something else you want to watch, with a question mark from the defendant to Ms. Beecham?
Yes.
And going back to this map of State's Exhibit 289, the time frame of 9:36 p.m., is that close in proximity to this, what is a 9:34 p.m. phone call on the 13th that places his ANS phone in that vector?
I'm sorry, can you repeat that?
Sure. So the message I just showed you came in at 9:36, or was sent at 9:36 p.m. roughly. Correct. Is that close in time frame, 9:36 p.m. to this phone call at 9:34 p.m. on May 13th, 2020, that placed that same ANS phone in the vector, including Mr. Gutierrez's residence?
Yes.
Okay. A little moment of silence.
Approach with States 312.
That is in response to Frenchie Irish. Is that Olivia sitting next to her mother? I didn't see, but I'm going to say no. Wow. This is riveting testimony from their final witness.
I'm thrilled.
Are these audio files recovered from the Moto G6 when the download was done? Let me zoom out here. Appear to be 8 of them in total, 7 on the first page, 1 on the second.
Yeah, they appear to be.
And in your review of this case, you previously testified that there was a voice recording app installed on the phone in April of 2020.
Yes.
And in reviewing this case, were these calls, or sorry, not calls, but audio recordings listened to as part of the investigation?
I did.
And without getting into specifics, what in general was, I mean, who were on these calls? What were they essentially entailing, if you know?
They were primarily between Ms. Beecham and the defendant. Then also the daughter in common was also in some of the calls as well. Not in the same call, but separate.
And so it was Ms. Beecham
and the defendant, and then also the defendant and the daughter in common.
So it's combinations of those 3 parties being recorded during conversations?
Correct.
And ultimately, the top one looks like it had been deleted but recoverable. Is that accurate?
Yes.
And then the rest of the 8 all appear not to have been deleted. Are there essentially date stamps of when these occurred, given what the file names are?
Yes, there are dates associated with them.
So, for instance, the top deleted one, it says 2020, 05, 08, 13, 47, 54. Would that be May 8th, 2020 at 1:47:54, given military time?
It appears that would be the date, yes.
And so then we see audio recordings from May 13th, given that. It looks like audio recordings 2, 3, 4, and 5 are all from May 13th, accurate?
Yes.
And do we also know that too, because on the right it says when things were created and the dates match?
Yes.
And then we have audio recordings number 6 and 7 on this page, both say May 14th. Is that accurate?
Yes.
And then this one
Defense
says May
can call for a
16th.
mistrial.
Yes.
So if
And
they're
then I
not
would ask, if we look
not
at
gonna
these records on the right-hand column, is there also a place where it shows created, modified, and accessed?
Not yet.
Yes.
So in looking at that second call, for instance, created on the 13th, but accessed on the 18th of May,
Yes.
and the third call was accessed on the 19th of May.
Yes.
Fourth call, same thing, created on the 13th, but somehow accessed on the 19th.
Yes.
The remaining calls on this also accessed on the 19th.
Yes.
And same with that last call, or the last audio recording, accessed on the 19th, although it was created on the 16th.
Yes.
And were these recordings consistent with the recordings that Officer Morton testified about on the MSI laptop? I think he said there were like 3 dozen.
Yes.
In terms of parties involved.
Yes.
So during the search warrant of the defendant's home up in Mequon, do you recall a large amount of cash being located in an ottoman in a bag?
Yes.
I'm going to show you what's been previously marked as State's Exhibit 1, image number 296.
Feel bad for when Hayden shows up and asks me what happened today, and I'm going to go, eh.
Does that appear to be a picture of that large amount of cash that was recovered?
Oh, I thought Hayden would be with us early.
In case I misspoke, I was not part of this search, nor was I part of the actual counting of.
What?
We try not to get too many people around a large amount of money. But so my viewing of this was through photos.
Right, as a case detective.
Yes.
And in total was just under $48,000.
Object to hearsay and speculation. He just said he didn't count the money.
Judge, it's collective knowledge of the investigation as the lead.
Right, but it could be a bundle of money and I don't know how much is in there. If I don't count it.
This has already been testified to, Judge. Yeah, we're not.
That may be,
So
but,
we'll do.
I will withdraw the question. I'll move on. That's not paramount.
Yeah, you'll withdraw the question now that everybody's seen there's $48,000 in cash in a bag in an ottoman. Now you'll withdraw the question. I hate when they do that.
It's in a plastic
Yeah, that's
bag
pretty
or a
cool.
gray bag. I'm going to show you what's been marked as State's Exhibit 321.
Here comes the buds the daughter didn't recognize.
Yeah. Bye, friends. What the hell does the money have to do with anything? He was selling weed. Well, he was selling weed, and selling weed is wrong, so he did bad things, and so therefore he murdered
So is
somebody.
this a different angle of that bag where that money was located?
Nothing.
Yes.
And specifically on this bag, can you see the name Wells Fargo Bank?
Yes, it's on the, should be my right side. It found, call this Wells Fargo Bank number, and it provides a partial number.
And I'm now going to show you State's Exhibit 49.
Givner says, if that's all the recorder got, I'd want my money back.
49. When you were looking through the defendant's email address, that same zjaii@hotmail.com, did you locate this receipt?
Yes.
And is this a transaction receipt from Wells Fargo Bank on May 15th of 2020 at roughly 3:38 p.m.?
Yes.
And how much cash was paid to the customer associated with this bank account?
$50,000.
So he withdrew $50,000 from his bank account. Ooh, crime.
It says loose currency 20.
And
What does this have to do with stalking and murder?
in their 20s?
Based on the photos that I saw, yes.
Right. So he took 50 grand out of his bank
And that transaction
account.
happened on May 15th at 3:38.
Yes.
So effing what? He can take out $50,000 from his account and put it in a box. He can set it in the middle of his living room and light it on fire. What the hell does that have to do with committing murder or stalking?
The bank allowed it. Who cares? Why does it matter?
Yeah.
Michelle says bring Joe in so the trial gets interesting.
Did he also have passports and fake
During your
mustaches in his car?
investigation-
Like, was he going to go on the run?
At some point, did it focus in on the late evening hours of May 17th of 2020 as a time you believe Mr. Gutierrez ultimately went missing, we'll say?
You say May 18th?
May 17th.
Oh, 17th, yes.
And in knowing the relevant time frame that you believed based on your investigation, did you look at the cell phone records of the defendant to see where he had been at that time?
Yes.
And ultimately, was his ANS phone found to have been in the general area of his home during the late evening hours, we'll call it mid-afternoon to late evening hours of the 17th?
Well, there was a gap in the records. I believe at 9 or 11:19 p.m. The phone was that way, and then also I believe right around 6:30ish, 7 o'clock. But then there was a gap in time that I don't know personally where that was.
Okay. So I'm approaching what states 316. I'm showing you the ANS phone records from May 17th. Of the defendant's phone. Oh, hold on, autofocus. There we go. So
This is 316, counsel?
Yes, 316. So on May 17th at 7:34 p.m., does this phone make a call to someone in the phone as N civilian?
Yes.
For 23 seconds?
Yes.
And then the next thing with the phone, at 7:48 p.m. that day, there's a call from N civilian that's not answered. Is that accurate?
It appears so, yes.
And then at 8:13 p.m., there's a call again from N civilian that is not answered.
Correct.
Then at 8:45 p.m., there's a call from AZN shop that is not answered.
Correct.
Then at 8:47 p.m., there's a second call from AZN shop that is not answered.
Correct.
At 9:20 p.m., is there a text message from someone in the phone as Fry that says, "Get to keep the kiddos tonight?" ?
Yes.
And then at 10:31, is there another message from someone in the phone listed as Fry that says, "Whatever, going to bed?"
Yes.
And then at 11:19 p.m., do we have then affirmative action from the defendant's phone back to this Fry saying, "Fell asleep, sorry, missed afternoon nap"?
Yes.
So from the phone call that was to N civilian at 7:34 p.m. until the text message to Fry at 11:19 p.m., was there any activity regarding phone calls, text messages that were responded to by the defendant's phone during that almost 4-hour time period?
It doesn't appear so.
So after a full work week, he fell asleep on an evening.
Well, in this little break here, we've got 2,370 people and 1,717 likes. Do me a favor and hit that like button, and do me an even bigger favor and hit that subscribe button if you haven't already done so. That would be awesome. Because currently, what are we looking at? Currently, we are looking at 35,708 subscribers. 298 if you just get down there and smash that subscribe button, get up to 36,000. That'd be awesome. I would love it if we could get up like 36,000 subscribers today. You'd make me happy. The sooner we get to 36,000, the sooner the district attorney stops talking. I think that's how it works. I'm not sure. Let's give it a try and see what happens. And go over and subscribe to Nicholas as well. And go to Twitter and follow Chandler Remington. Remy, REMY_legal.
You'll find me on Twitter by this name as well.
Exhibit 309 from the defendant's Moto G6. Are these a collection of Google searches that happened early that morning, starting at 4:18 a.m. on the 18th, sorry, May 18th, 4:18 a.m. For these searches?
Yes, they appear to be, yes.
Okay. And so there's a search at 4:18, another one at 4:18, one at 4:19, and one at 4:58 a.m. Is that all accurate? So now I'm going to show you what is on stage 1.
There better be how to get rid of a body in that Google search.
This is going to be on States Exhibit 1. It's going to be item number 340, and it's from May 18th at 4:18 a.m. Detective, is this then a search for Lowe's hours made on the defendant's
Well, there you go.
phone at
He went to
4:18
Lowe's.
on the 18th?
He would spend $50,000 buying like 3 or
I
4
believe
pieces
so,
of
and
wood these days.
There was a search for Lowe's. I guess, can I look at the document to compare it to the photo? Just so I'm, because I believe there's a thumbnail associated with each of the searches.
Apologize. The thumbnail's not real clear, so I don't necessarily know this is going to help you, but
What are you showing so that she knows what you're?
States Exhibit 309, which is just a record of the searches with tiny thumbnails. Detective, why don't I just withdraw that question? I'll ask it a different way that doesn't require you to put on your bifocals or whatever.
Put on his bifocals. You're old.
In the early morning hours of May 18th,
I have
there were
bifocals.
a series of searches
I'm old.
on the defendant's Moto G6 phone.
Yes.
And what were those searches looking for specifically that you can recall?
Store hours for, I guess, like general home improvement stores. I believe Walmart was on there, Menards, and then I believe Lowe's. I don't recall.
Was Home Depot also on there?
Home Depot, yes.
He's literally getting ready to go to a job site demolishing a
Searches
house.
happened between 4:18
It makes
a.m.
sense.
and
That's where he's
4:58
going.
a.m.
Yes.
Della Sanders, that's just Judge Schroeder having a stroke. I don't know. There is no mic drop
Ultimately,
here.
as part of this investigation, was Walmart video recovered from Saukville Walmart?
Yes.
And is that something, as part of being the case detective, that you reviewed as part of your investigation?
I did.
I'm going to play.
What are you going to play?
Is this deja vu all over again?
I'm only going to play a very small part. I'm not playing.
Are you playing any of it?
So he can point out which vehicle is the defendant's in terms of his review of the video. It's going to be very brief. It's not going to be playing 20 minutes of watching them walk around the store.
The Walmart person, of course, is unable to say which vehicle matches that.
Okay.
If your polls suck and no one likes them, well, what a coincidence. You suck and nobody likes you, recovered alcoholic. Burn.
Well, what I really want to do is move forward.
Sounds good to me.
I actually could use some trifocals. I need some good mid-range vision. I'm either looking like this or looking like this. There, that's enough about my eyesight. Andy, behave yourself. Chaos coordinator Alexa, play Rick Astley, Never Gonna Give You Up. I was thinking that would be hilarious. I was like, about 2 hours ago, I was thinking that would be hilarious if Gutierrez just came into court playing Never Gonna Give You Up on like a stereo. I actually had that
So
thought
Detective,
2 hours
I'm going
ago.
to play clip number 2, and I'm going to start it at just after 8:17 a.m. So if you could approach the TV screen and point out when the defendant's vehicle pulls into this lot.
Didn't we go through this yesterday or the day before?
Yes.
A contractor going to a store to buy contractor supplies.
Yeah.
Shocker.
Okay, so that dark
comes very quickly from the left.
And so that was the defendant's vehicle pulling into this parking lot?
Yes.
And then is that him exiting the vehicle now and heading towards?
Good one.
And obviously there appears to be some kind of obstructions on the camera lens itself. Is that water from rain in terms of making certain things look a little blurry?
Yeah, so it was raining out that day, which is, as you can see, and it appears that there are raindrops or wetness in those blurry areas.
So, but that vehicle at the top left portion of the screen is the one that the defendant arrived in, that minivan?
Yes.
I provided judge, we're brief, that's all we needed to see. And for the record, that's on State's Exhibit 1, item number 322, clip number 2, roughly 8:17 a.m.
See, Jason J makes a good point here. I've been unsubbed. I only miss an hour of the trial today. YouTube randomly drops subs. That's why I always say, if you haven't subscribed, please do. And if you have subscribed, just check down there and make sure you still are subscribed, because that's a real thing that YouTube does, and God knows why they do it. Moral of the story, folks, says Feral Housewife, never nap ever, and certainly don't shop 2 hours after a store opens. Also, don't use Google. Can't argue. I wish I could argue with that logic, but I really can't.
Yeah, don't buy trash bags. You'll be accused of murder.
Yeah. I missed this morning the quickest possible way to explain how they avoided the mistrial debacle from yesterday. They agreed that they wouldn't ask her any more questions and they would move on. I'm not sure if they agreed to strike the testimony about the threat with the gun or not. I don't think they did, but I can't remember. Jonathan, hello, Chandler, Nicholas, and other guy. No mistrial yet. Is the judge still pondering?
Nope. To the Wood Creek Apartments with Miss Macias in March of 2022.
Yes.
And on this, whenever it comes up, is this a map? It states Exhibit 1, item number 320. Is this a map overview of the Wood Creek apartment complex?
Oh my God.
Yes.
And when you met with Ms. Macias back in March of 2022, which building did she indicate she had been parked in front of?
With a few strokes, I can actually spell out fuck.
And based on, you could probably...
You see it, don't you? Big F here in the beginning.
Judge, do you have a handheld mic for him?
Let's play the fuck game. What?
What's that game, Jeff?
Do they still teach clear, concise in law school? Yawn.
So can you point out that building that she was parked in front of again?
Right here.
And did she describe for you the different places in front of that building she parked?
She did. She said she had pulled up to this general area, and she had pulled forward, and she had also pulled like right into this general area here.
And on this map, what is Mr. Gutierrez's actual apartment building that you went to the crime scene of on May 19th?
Right about here.
And when you were interviewing Miss Macias regarding where she had parked, could you see that the side of the apartment building that Mr. Gutierrez lived on?
So from where she indicated she had parked at this location, you would not be able to see the front of the building. If she was here, obviously this building would be covering as well. And then if she was parked here, she would be looking kind of at this building here. So the only time she would have had a visual of this apartment would be this general area.
So when she was entering the general complex and driving to the building she stopped at?
Yeah, if she came in this way, yes.
And just to orient us, because maps aren't my thing, that building where Mr. Gutierrez lived, it's obviously 4 apartments on the main floor, 4 on the second floor. Is that accurate?
Yes.
And which direction did his apartment face out? So is he facing that parking lot, or is he facing what I would assume to be south towards that greenery?
And so this is north, and this is south, west. His apartment is, like I said, right about here, and it faces to the north onto 15th Street.
The day after the city planner quit his job, underpaid.
You can step back over.
It's like all those apartment complexes that are shaped like swastikas and things.
Should I begin now, or did you? What's your
no,
preference?
I think probably it's best to take a break at this point.
Okay.
Please don't talk about the case during the break. Read, watch, or listen on the account of the trial. And 1 o'clock, is that all right? Okay, we'll see you then. Thank you.
So it's 2 a.m. here, which means it's 1 a.m. So it's noon there. It's lunchtime, and Hayden is supposedly getting ready, but he's missing in action.
Yeah, where is Hayden? I really thought he was going to get up early and join us like from the beginning.
That's what he said.
I guess. But it was going to be really early in Australia, so I don't blame him for not being here.
Well, that was a smart decision of him not to actually get up and do this early, because
Well, it wasn't that exciting. We thought it was going to be more exciting this morning, but you know.
It's been exciting in chat because the chat is always awesome.
Mm-hmm.
The chaos coordinator says, whenever they say anything about chainsaws, all I hear is Limp Bizkit break stuff. I pack a chainsaw. What? A chainsaw. What? A motherfucking chainsaw. I always think of like Nick's new like handheld chainsaw commercial, but you win because you think of Limp Bizkit. You're cooler than me. Yeah. At least that's what I'll let you think. David Edwards, the police kept that money. Like, did we say 48,000? We meant $48 in a bag. Kelly R. Put Anderson in the storage buying a 60-gallon drum or move on. Right. And Delasander. Do they still teach clear, concise in law school? Jan? Apparently not. And Chris Catania. I would follow Chandler anywhere. Already bought a box of trackers.
Well, thank you, Chris. That's sweet and a little creepy, but I'm gonna hope that's a joke.
You can hope. Mangs. So did I get this right? Sadie's the only one that saw the bloodbath in his apartment, then mysteriously was cleaned up by Zach with zero. No, you got it completely wrong. If you've seen the pictures of the couple of blood spatter dots on the wall and the little bit of blood in front of the sofa and the even smaller amount of blood on the pillow, and that's all the blood there was. Everybody saw it. We all saw the same amount of blood.
So Sadie saw it. Then police were called there. They went to the scene. Zach was apparently never at that apartment because his DNA is nowhere at the crime scene whatsoever. So
yeah, all that sea of blood never happened. It was like
I believe
more
they
like
claimed he cleaned up his car, but there wasn't really evidence of that because the car was kind of filthy.
That needle pin of DNA that couldn't be tested for both blood and DNA. They said it couldn't be excluded for Junior. But how many did they test it against? Was it just him? 5 people? 50 people? Because if they can't, we couldn't exclude Junior, yeah, but if they only found, say, 4 markers, well, that's probably 25% of the male population they can't exclude. Yeah.
So
John
it's not
Gary
very
says it
strong
was not a little bit of blood on the carpet. Well, I mean, in the grand scheme of a murder, when the law and crime escaped, we have to fix that. Hang on.
Well, that's not what you said, Jeff. You said there was a little bit of blood on the wall, and there was, some blood on the carpet.
Yeah, but I mean, that is correct. A little bit of blood spatter on the wall is what I said. But I mean, still, in the grand scheme of things, when you compare the amount of blood that was in the picture on the floor with the prosecutor saying that there was, I mean, he said that other than the void of blood where the missing carpet was, every livable surface in the house was covered with blood. That is what he said.
The walls, he said there was blood everywhere, covering every, surface, every inch. That was not accurate.
That's literally what he said. Every livable space was covered with blood. And it was.
And then when you see the photos, it's very confusing because, there is a little blood there, sure, but it's just kind of like a small pool of blood. It doesn't match what he described.
And prosecutor, he goes, picture The Shining. Well, that was the image he gave. We were saying like The Shining or like the prom scene in Carrie, things like that. Or the one I used was Johnny Depp getting sucked into the bed and spat out in the original Nightmare on Elm Street, where it's just like a gout of blood coming out of the bed for 5 minutes. But so there's
both had Dexter, I think.
Dexter,
where he opens the hotel room and just like the blood spills out everywhere. Not like that.
Do we actually have a Hayden sighting? Or
I haven't seen him.
Hayden, I'll have to text him.
How can we summon him? Is there a beacon that we can employ?
Well, apparently, I hope he's asleep so I can call and wake him up, like he woke me up after 2 hours sleep. There, I've texted him. Those Lysol wipes, they are actually really good. They are. I mean, they're not going to clean up a bloodbath in the back of your van, but they're still pretty good.
Somebody investigate this guy. That's clear evidence that person's a killer.
This is literally the last witness. This is the guy that's supposed to be tying it all together. This is the guy that's supposed to be going, you go, oh, I see how everything connects. He's Mr. Connect the Dot. And it's not happening. This is it. Their last guy.
You never know how a jury puts it all together, but
Natalie's back.
Maybe,
Hi.
Hi.
But yes, we refer to this in the business as the golden thread witness.
Yeah, I'm not seeing it at all. We're just watching. We're looking at things we've already. Oh, Hayden says he's just getting set up. He's just literally showing stuff that's already been shown and adding nothing to it.
Cumulative. Move on.
Yeah, it's somewhat of a timeline, but maybe it's proof stalking. But I don't see anything so far.
Yeah.
As someone in the chat said, unless, or I think I said it too, unless that Google search on the 18th says how to get rid of a body, there's no evidence of Zach killing this guy.
I mean, I don't want anyone to know what I search on Google.
Yeah. I'll just tell him I did it for my job.
That's true. Oh, I meant more of just embarrassing things. I mean, I don't even want to get into it.
Well, okay, we do have a super chat that I thought you could answer better. And this was from like 3 hours ago. Carpe Deegs asked, off topic, tips for writing a personal statement for law school admission. Looking at an MLS with concentration in health, law, and policy. The last time I had to worry about that was about 31 years ago. So I have no idea. So you're much closer to worrying about that than I am.
I don't know if there's anything like specifically, I think, about you, experiences that you've had that allows you to think differently and provide a different perspective from different people is something that'll flag your attention. Honestly, one of the admissions people from when I went to law school afterwards had told me, it was like a meet and greet when I first started law school. You're introducing people to getting met to people. And this admission lady remembered who I was because I studied opera briefly in college. Like just that little thing, like drew her attention to me. So I think that if there are little interesting things about you, especially if you are well-rounded in different ways, like I also took 4 semesters of Swahili in college. This is, in my head, me being like ADHD and not really knowing what I like to do. And so taking a bunch of different stuff, but you can very easily twist that into being well-rounded. And they like people who think differently from everybody else, because that kind of, encourages discussions, things like that.
All right. Well, doesn't seem like it's changed that much in 31 years.
I was gonna say, that's all I got.
Yeah. Legendary Racing. Yes, Natalie, tell 2,200 people what you'd be embarrassed if one person sees.
Okay. Well, I mean, I can tell you something that's funny, but not embarrassing is like, for a while, I thought about writing like a biography based on my Google search history. Because sometimes you just like go back and look and see like what you were doing. And I'm like, oh, I remember what I was doing because I remember searching for that. And how it started was a search that I had done on whether or not packing peanuts are toxic to cats. So
all the predictive texts, like that's literally about 50% of the time, no matter what I type, comes up, is it bad for dogs? And we have oh, thank you, Jeremiah Hutchins, for being the newest member of the Legal Vices Clean and Sober crew. We do have a question for Nicholas. What's your opinion on the Atishtup? Greetings from Vienna. Okay, first you have to explain what this is. This is hilarious.
Okay, Ättestupa. The English translation is, it can be either old folks' home, where the poor people go, or it can be that punishment where you're on the town square, going like this. And my opinion is that don't punish people in the public like that.
See, I thought they were talking about like the cliff that people in Norway would jump off of at the end of their Viking days when they're no longer useful to people and they haven't been killed in combat. So they delete themselves for the betterment of the group. Oh well.
Yeah, like in Midsommar.
Yeah. They did that in Midsommar.
Sorry, I don't know Swedish culture except through movies.
They did that in Midsommar. That was like one of the worst movies I've ever seen in my life.
It was something else.
It was great for about the first 25 minutes, and then the last 3.5 hours were like, what the fuck am I watching? And then it just got annoying.
Are you watching Tess of the Dubervilles? I don't think it was that long.
It was like it seemed like it was like 3.5 hours. Oh well.
Anyway, I prefer to learn about Swedish culture from Niklas instead of Ari Aster. So very interested in hearing your take.
Well, Midsommar is not a documentary, that's for sure. But if you, we do weird stuff at Midsommar. We do that. We have that big phallus symbol stuck to the ground where everybody dances around it.
The maypole?
Sing about little frogs. Yeah. And
Liver frog.
completely pissed out of our faces. Yeah.
That's my kind of thing. All I know is that, okay, my summary of all of my problems with the movie Midsommar. All of your best friends disappear and you don't ask any questions. It's like, wait a minute, there's no way out of here. Skippy's gone. We heard a big scream last night, but oh well. I'm sure he's okay. Well, that was a bad movie. All right, before we get too far off track, welcome back, Natalie. Any particular comments? I know you were working and dealing with like real life issues there. I don't know how much of this you caught while you were traveling back and forth.
I mean, I listened to things. My question was, if we're going to talk about all this weed, I mean, was it at least good weed? If he's growing weed, like that's going to be more of my judgment against this man is the quality for growing weed is the quality of the weed. So if we're judging this man for growing weed, I want to know exactly what strains were involved.
Did you see that picture of the little baggie where they asked the daughter and she was like, I don't know. What
Yeah.
It didn't look that good to me. I mean, it didn't. I mean,
it's hard to tell with that type of picture. You don't know if it was shot, like how well it was. You got to get close enough in there. You got to be able to, see the colors, all the purple.
You can't smell it. You can't, so it's hard to tell.
Well, see, and I hate these like bags of cash things. There's nothing illegal about having bags of cash. And he took it from the bank. It's not like they literally showed a paper trail where he took it out of the bank. And then he goes to Home Depot or Lowe's. He searches for those places and he ends up going to Walmart. Okay, he's a contractor. He deals with things. I mean, as I was only half joking, go to Lowe's and buy like 6 pieces of 2x4 wood, and that's $50,000 right there. People have need for cash. You have loans to repay. You can be going to make a down payment on something. You can. It could be anything.
Yeah, and maybe he just wanted to throw it all up in the air and make it rain on himself. Who cares? It's his money.
That's exactly what I said.
If I was going to ever withdraw $50,000 from the bank in cash, I mean, I might do it just to throw it around. Who knows?
Well, that was weirdly part of
the whole thing. Make like a money angel.
Yeah, right.
Be like who was the big guy on Breaking Bad? Just laid back on the pile of cash.
Oh, yeah. What was his name? I can't remember. Something with an H, I think. Huel. It was
Huel. Yeah, I was thinking Buell. That's a motorcycle. Yeah, Huel. Okay. But, yeah, I mean, you can take it out and put it in the middle of your living room and light it on fire, if that's your thing. It's yours.
I agree with all of that. I also think a reasonable juror might ask, what was he going to do with that money? And if they think ill of him, or if they think he's a sketchy guy, they could find it suspicious without an answer. Just throwing that out there.
Well, and I will say that when I saw that my divorce was imminent, I took out a chunk of cash and I put it in a safety deposit box in the bank. I was protecting that cash. I mean, thankfully, we didn't have to do all this asset division because it was all relatively amicable. But yeah, I put a little startup, little seed money, I in cash in a safe deposit box. So yeah.
I wonder if Sadie had access to that bank account. I mean, they weren't married, so there wasn't any indication that she did.
Imminent divorce money thief. I'm confessing to murder. I'm Jesse's girl. I wish that I had Jesse's girl. Sorry, I couldn't help it. Hayden, I'm dying here. Get set up. I've started singing. Was that Rick Springfield?
Yeah, and I had to chime in off key, of course, because I love 80s music.
Yeah, hurry up, Hayden. I'm singing 80s songs here. I'm tired.
It's a great song.
Money is cool. I hope to get some one day. I feel you. So you're like, wow, you're a lawyer. You must be rich. I'm like, yeah, I'm making my boss fabulously wealthy. It is a fire hazard, but you know, if you're homeless, you can just light it outside. The world is your living room.
Just put it in one of those big, barrels.
Yeah, you don't want $50K in the bank if you're going for custody/child support battles, but you don't want to be hiding assets either. That can go very, 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 very poorly for you.
True.
Aussie Overlaw'd finally in chat. I don't have to sing Rick Springfield songs anymore.
Yeah, I as soon as I heard that, I came running. Come on.
And Jonathan, Nicholas, I'm assuming that's for you.
He's asking, when did you find LawTube? He started watching with the Rittenhouse. He thought he was the only Swede around. He saw my super chats. Well, I've been watching EDB for quite some time, but I really wasn't that into this segment until the Depp versus Heard trial.
Well, and then you found the better place.
Yeah.
And then you decided to go your own way and make your own channel.
Yeah. Yeah, I saw all the other idiots making money out of this, so why not I?
There you go. Wait. Oh, hey, Law and Lumber in chat here. Nicholas's humor is epic, says Law and Lumber. Where'd that go? Here we go. What's up, Rob? All right. Well, so we survived this morning here. So what's going to happen now is I'm going to make one more plea and beg for everybody to subscribe to the channel. We're taking we got to take this drive to 36,000. We are way far away from that. We need 280 more people. Like 7 of you subscribed since last time. There's 2,138 of you here. This is my last big grift. Everybody get over down there and hit that subscribe button if you haven't already done so. And if you have, make sure you're still subscribed. I want to get to 36,000. And all we need is 280 of you to do it. That's like roughly, 9.2%? Roughly. I have no idea. And hit that subscribe button, like button, and everything else. Take our poll. Flux says, I'm with Natalie. I didn't see any good terps or crystals on the plant. The quality of the weed is the quality of the man. LMAO. All right. I'll take your word for it. And the last 2 super chats, and then we will head on over to Aussie land. Jeremiah Hutchins just wanted to say thank you to you and the panel for entertaining and distracting me on a rough day 3 years ago. Today lost my dad. So sorry to hear about that. It's an anniversary. Hope we, as you said, hope we make it a little more cheerful for you. And Nick Campbell, plot twist. Sadie discovered Junior's girlfriend and baseball bat him. Mike took him to Mexico for medical. Then she thought custody battle frame job. It could be anything because the prosecutor hasn't proved what it was. So it could literally be anything.
Better than the state's case.
And Joe has just joined the stream about 2 minutes before we dump over to Aussie Overlaw'd. Welcome.
How are you, glorious bastards?
We are doing well.
Morning,
Joe. Happy to see you.
Have you been paying attention?
No.
Good.
No. Can I get 30,000? Why is this trial still going on? Why don't we have a mistrial? What happened? Can you just give me an update quick, like 60 seconds?
Yeah, they agreed not to talk about the girl anymore.
Yeah. They
No more
dismissed her.
questions. Get her off the stand. Never happened. So yeah, well, not never happened. They didn't strike anything. They just said we're not going to talk to her anymore. We're done.
They didn't strike anything? I thought they struck nothing.
Did they? I don't recall. I honestly.
He did instructions to the jury to ignore because it was not related to this trial.
Ignore the gun thing.
Ignore
he
the
gave
gun
that
thing.
instruction. Oh, okay. I'd only had 2 hours of sleep by the time Hayden called me and told me I had to hear that absolute disaster.
Well, I recall they moved to strike the entire gun testimony, and then the DA said no. We're not going to do that. And then they kind of haggled for maybe like the last part of the testimony, but I don't know if they got that out or not. I think that was what I left.
Yeah.
So.
Wow.
So it says Chad is unanimously saying they struck the gun talk.
All of it?
so not good enough?
No,
not
It's not going to do anything for the jury who heard it.
I want to
not
just
gonna
point
change
this
anything.
out. I want to point this out. Just if you think about this for a second, okay? We just spent the last 2 months watching a man from South Carolina get convicted of a double homicide of the 2 people out of 3 on the planet that he actually probably loves. That he was found guilty beyond a reasonable doubt, despite a dearth of evidence, almost no evidence that really showed that he's the one who pulled the trigger.
Mm-hmm.
And found guilty beyond a reasonable doubt of killing 2 people that he actually, according to all testimony, really loved. And the whole conviction was based on crimes, 50 different crimes that he probably committed that were not lethal crimes, 50 crimes against people that he really didn't give a damn about. And they saw these 50 crimes against people that he didn't give a damn about, non-lethal, and said that he went lethal for no reason against people that he loves beyond a reasonable doubt. That's what we saw happen in South Carolina. And that was allowed to proceed, and we saw him get convicted. Now this defense stipulates and says, oh, our client is being charged with murdering his enemy, someone he's stalking, and there's really no contradictory evidence. It's just perhaps a lack of sufficient evidence. It doesn't seem like there's much contradictory evidence as far as I've heard. And the jury just heard that he threatened to kill his own daughter. And now we want to have that jury sit there and think to themselves, well, he threatened to kill his own daughter, if they believe that at all. And now we want to figure out, did he kill this missing person who was a bitter enemy who he hated and was stalking?
Well, I'm going to push back a little bit here on this, Joe. In my waning moments before we go over to Aussie, I say it makes sense they didn't ask for a mistrial. The defense didn't ask for a mistrial because they've already had one already a year ago, and their client has been sitting in jail for 3 years already. If they asked for a mistrial, they probably would have gotten it. And that would just mean he's back in jail for another year. And during that year, the prosecution essentially gets a do-over, and they decide who they're not going to call, which will probably be like 90% of their witnesses. They can refine their case, look back where they made the mistakes, and make a better case. So I think they just want to press through to one, get it over with, because they have plenty of grounds for appeal, I believe. But again, appeals are for losers. But I think they want to get it over with now so they don't give the prosecution yet another crack at it.
I don't think Schroeder would have given them a mistrial. I think he would have denied the application. You preserve the application. You preserve the appeal on this basis, which is I imagine is probably their strongest basis. I'm just saying. I don't know what the other bases are. I'm just saying you're doing it as a tactical basis, if for nothing else. And if you get it, that means, think about this. If you get it, that means the judge says, yeah, that was really prejudicial. He's there in the courtroom. He's feeling it. And that would be his admission that, yeah, that was ridiculously prejudicial. We can't fix it. So that's why I respectfully, I love you, but I completely disagree with you on this one. If you're getting it, that means the judge is like, yeah, we can't, no matter what I do, I can't save it. That was really, really terrible. And he's there in the courtroom. We're not. He saw the faces of everyone there, including how credible or lacking credibility the witness had, which is no way for us to know that without seeing her face. And
well, even if you do get a mistrial, though, on those grounds, that isn't going away. People that when the trial comes around again, people are still going to remember that. The news is still going to bring it up. Law and Crime and Court TV are still going to harp on why it was dismissed the last time. So I don't know. It was a no-win situation, and I think this is probably the defense decided this is the best way for them out of it.
Yeah,
I don't know.
Yeah. Well, anyway,
how are we doing, Aussie? We getting ready to go live?
Send the link in the private chat. I'll pop over there and join you.
Schrader made it sound like 2 strikes, you're out. Well, that would have been 3 strikes because that was the third near mistrial we've had in this trial. And I don't think it's any mystery, but I believe that the prosecution and the defense genuinely do not like each other. I mean, the forced professional courtesy is obvious. They're tolerating each other's existence. Chappie said, I bet the DA watched Murdoch and said, hey, let's do that.
That's a great comment. All right. Links in chat. Everyone's, of course, welcome to come across. My regular guys are already over there and revolting, so I'm going to duck across.
All right, so you're already up and live, are you?
Yep.
All righty, then we will shut this down, and everything is locked and loaded to go over to Aussie Overlaw'd. Everybody here on the panel, the link is in the chat, in the private chat. Everybody, thank you for this. What we've got to do here? Oh, one more comment from Law and Lumber. Law and Lumber says you got to know your judge. With this judge, you have to push every issue to the nth degree. Every fight must be had, and I guess they decided to not have that fight, and they all agreed to be nice to each other. Thank you, everybody that was participated in chat. Thank you to all the mods. The panel, as always, is the greatest panel on the entire internet. And the end of the like and subscribe poll was 15% of you said you hit the like and subscribe button so the DA doesn't shout at you. 19% of you said you hit the like and subscribe button because you knew I'd tell you to do it. 31% of you said you hit the like and subscribe button because only Law and Cuck fans don't. And in number one place with 36% of the vote, you hit the like and subscribe button to avoid a mistrial. There we go. That's it. Thank you so much for your generosity today with the awesome super chats, with the amazing conversation, with the amazing people, the amazing Natalie Wisco, who you can get at NL Wisco, the amazing Nicholas Starov, Union Rep, Labor Law, where you can find him at
I've
that.
seen him on my channel so many times. It's my first time getting to see you in person.
Oh, is it?
It's my privilege. Yeah, thank you. Thank you for but wrap us up. We're closing.
Yeah, let's all go get acquainted over there. And Chandler Remington is Remy REMY_ legal at Twitter. And Good Logic Joe is everywhere. Good Logic here. He's over on Twitter at the never ever will remember it. The following program. I remembered it.
No, not
just
Graham,
just the following pro.
The following pro.
Like
following
I'm a
pro.
at following.
Yeah.
There you go.
You are.
I'm following.
All right, and me, I'm Legal Vices. I'm here every day. We'll see you tomorrow for more trial in the morning, and then in the evening I will be over on Flux's channel where we will be doing a unexplained stream where we talk about unexplained things. So, all right, and we're going to wrap this up. I'm going to end the stream, and what's going to happen is you should be redirected automatically over there. If that doesn't work, there's going to be a little box up there at the top of the chat that says, hey, something's happening over there. Go check out what it is. If that doesn't work, you're just on your own. That's it. We'll see y'all tomorrow, everybody. Catch you over on Aussie in a few minutes. Love y'all. Catch you tomorrow. Bye. And